to call our meeting to order and ask Secretary Brash to call roll.
Ron Jones,
Present.
Victoria Brash, present. Tian Feng, Rita Kanani, Leonard Manukian,
Here.
Robert Fairman,
Present.
Gilma Serrano, here. Amanda Stilkemeyer, sorry, Steidelmeyer, here. Rod Speed,
Here.
Sunny Work.
It appears that a quorum has been established, so we'll move on to the second order of business. I'd like to acknowledge Chairman or Chairperson Pamela Brief from the LATC. I think she's online. Again, thank you as always for your participation and your attendance. I should also note that all motions and seconds will be repeated for the record, and all motions will be taken by roll. We should also note that the public comments will be limited to just 2 minutes. The chair will now open the floor up for public comment on items not on the agenda. It should be noted that discussions or no discussions or actions can be taken on any item raised during this public period, except to decide whether to refer the item to the board's next strategic planning session or to place it on matters of the agenda in future meetings. We should open the floor for public comment. To the facilitator.
He usually checks to see if there's any in-person person. Oh, no, so seeing none.
Seeing none, can we check online comments, public comments, please?
Absolutely. We are open for public comment via WebEx. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. For our dial-in users, you'll need to dial *3 to raise your hand. And for our mobile device users, you may need to hit the ellipses button at the bottom, the ... in order to find your hand. People will be given 2 minutes to speak, and I'll give you a 30-second warning before your time expires. We're going to take just a few more seconds now to see if we have a request for public comment. Seeing no request for public comment, do you wish to continue?
Yes, please. Since there's no public comment, we'll move on to agenda item D, update from the Department of Consumer Affairs.
Mr. Chair, it does look like Member Fang has joined. If we could do a mic check and video check for him.
Thank you very much. Member Fang, please acknowledge or present yourself in a mic check, please.
This is the moderator. It appears that Member Fang is unmuted. Member Fang, are you with us?
Okay. We don't need them.
Come back.
We will move on and come back to check the audio for Member Fang. We'll now move on to agenda. Again, I'm going to go back and ask for DCA's presentation.
Morning. Morning. Happy Friday.
Now it's on. Good morning, I'm Shelley and I am with the Solid Unit and I'm here representing Board and Bureau Relations to provide your update today. I have just a couple items to cover. The first is the governor's reorganization plan. In January, Governor Newsom released his proposed 2025-2026 state budget, which included a proposal to split DCA's oversight agency, the Business Consumer Services and Housing Agency, into 2 separate agencies: the California Housing and Homelessness Agency and the Business and Consumer Services Agency. The proposed California Housing and Homelessness Agency, known as CHHA, will oversee housing and homelessness solutions and safeguard civil rights. The new Business and Consumer Services Agency will be responsible for consumer affairs, licensing, and enforcement. The Department of Consumer Affairs will be among the 8 departments in this new agency. We believe this is an extraordinary opportunity for DCA to better align with other consumer protection departments. A secretary within the governor's cabinet focused solely on consumer protection will only strengthen our mission, momentum, and delivery of services to California. As a part of the process in state government, on April 4th, the governor's reorganization plan was delivered to the nonpartisan Little Hoover Commission for review. The submission of the plan to the commission began an approximate 90-day formal review process. The commission held public hearings on April 23rd and 24th to receive testimony and for interested parties to provide input on the proposed reorganization. Our agency's secretary, DCA Director Kirchmeier, and other impacted department leaders testified in support of the governor's plan and responded to questions from the commissioners. This week, the Little Hoover Commission released its full report, recommending the legislature allow the governor's reorganization plan to take effect. The commission also included recommendations that would build upon that plan. The legislature now has until July 4th to consider the reorganization proposal, and unless rejected by the legislature, it will go into effect on July 5th. As written, the Business and Consumer Services Agency will officially become operative on July 1st of 2026. We anticipate one or more legislative hearings will take place in the coming weeks, and DCA will continue to keep the board and bureau leadership apprised as these are scheduled. Moving on to our hybrid telework transition. On March 3rd, 2025, Governor Newsom issued an executive order requiring all state agencies and departments to update their hybrid telework policies for employees and increase from 2 to 4 days in office per week beginning July 1st of 2025. On March 13th, the California Department of Human Resources issued guidance on implementation of this executive order. The guidance provides defined parameters for when agencies and departments can make case-by-case exceptions to the 4-day in-office minimum requirement. DCA has been working closely with a few programs on identifying additional space needed for this transition. DCA has also been hosting biweekly meetings with board and bureau leadership to provide updates and respond to questions. We recognize that this transition will likely require adjustments for many employees, and we are working together to minimize the impacts. We will, of course, continue to keep leadership updated on any additional direction that we receive from CalHR. And lastly, we have a new compliance and equity officer. On April 28th, Levi Hull began serving as DCA's new compliance and equity officer. In this position, he is responsible for leading and coordinating department-wide quality improvement efforts to ensure consistency and regulatory compliance. This position oversees DCA's solid planning and training services, the Organizational Improvement Office, the Equal Employment Opportunity Office, and the Internal Audit Office, and serves as the liaison to the department's Diversity, Equity, and Inclusion Steering Committee. As the department's equity officer, this position is dedicated to enhancing the diversity, equity, inclusion, and accessibility policies, trainings, and activities throughout the department's programs. Levi brings more than 12 years of experience in leading multidisciplinary teams and driving strategic program development. With more than 9 years of experience in EEO compliance and program management, including nearly 3 years at DCA, he is an experienced leader with a deep commitment to fostering inclusive, equitable, and accessible work environments. That was all I have for today. Thank you for the opportunity to be here. And if you have any questions, I'll be happy to do what I can to answer them.
Thank you. The chair, any questions or comments from the board? We'll open the floor for public comment. Are there any public comments from anyone in person? Seeing none, we'll open the channels up to the public online for any public comment.
We are open for public comment via WebEx on agenda item D as in Delta. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a few seconds now to see if we have a request for public comment. Seeing no request for public comment, do you wish to continue with the agenda?
Yes, please. Thank you very much. Thank you for your presentation.
Right there.
I should mention that because of the participants of the board members and early travel plans, we've shifted the agenda around just slightly. So I'm going to be seeing some things out of order, but I just wanted to bring that to everybody's attention. And so now we're going to move on to agenda item F, the presentation and recognitions. So today is the last day of member Nilza. And so we are going to acknowledge her for her service to the board. And I can say personally, I've been here just for about 5 years, and you have been a joy. You embraced me when I first joined the board in a very passionate and sincere way. You hosted me when I was in Southern California. So I personally want to say thank you for your advice, for your mentorship, and I'm sure you will do great things in your next journey.
You also.
And an amazing. Thank you, thank you. The picture with Ron. Not.
Show it, move a little bit. Show the seed.
Yeah, he loves, he's a photo taker, that's for sure.
Lift your head up. Yeah, there you go.
Wow.
Okay.
Look at.
Paparazzi.
Oh my God.
Thank you.
And again, feel free if there's anyone else who want to make any comments, the mic is open to you.
Yeah, I'll take 30 seconds of privilege
Please.
if I could. I have sat on this board for now 13 years, and it has been a privilege to be able to provide thought and to provide my point of view in terms of DEI and ensuring that we have more students of diverse backgrounds to join this amazing field. I hope that when I'm gone, that the sport continues the same mission and the same passion, that we have to encourage diverse students to continue in this path. I want to remind also everyone that we need to look forward and know that we are going to have a void of architects if we don't ensure that United States students get into programs. So please continue on that journey. Don't forget that students matter, and we can't let them not have the career they have chosen. Again, this has been a privilege to sit on this board. So thank you so much. And to the staff who has been amazing, Laura and Drew and everyone else, you guys have been so great in providing guidance, and anytime we have questions, you're there. And I just can't thank you enough for the opportunity to be part of this team. Thank you.
Let me just echo what Ron said about her, and also for those who aren't familiar, point out, not just on California's board, but she's been a leader in pushing things on the national level through NCARB, very much an influential voice, and we'll miss her. Thank you.
I just want to say thanks to Niels as well. She's been a member since 2013, so she's put in a lot of service to the board, and she's one of the most responsive members, always prepared and just always there for whatever we need. So I've enjoyed your time on the board, so thank you so much. Thank you for your dedication.
Thank you very much. If it's appropriate, I'd like to acknowledge our newest member of the board, and Amanda Stottlemyre. She has taken the place of the retired board member and Brett Gladstone. So welcome, Amanda. Look forward to sharing the discourse with you and hearing your points of view, and excited about your participation. So we will open it up now for public comment. First, for those in person, if there are any, please come forward. Seeing none, we will ask the facilitator to open up the channels for the online attendees for any public comment.
All right, we are accepting public comment. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a few seconds to see if we have a request for public comment. Seeing no requests, do you wish to continue with the agenda?
Yes, please. Thank you very much.
Before we do that, I have an announcement to make. Can we check in on Member Feng? Member Feng, will you please unmute and do a mic check with us?
Can you hear me?
Yes. Thank you
Okay,
so
thank
much.
you.
All right. And I would also like to remind all remote board members that the cameras need to stay on. All right. Back to you, Mr. President.
Thank you very much, and welcome, Member Tiang. We will now go to agenda item N as in Nancy and ask, which is our regulatory updates, and ask for Tim to come forward, please.
Thank you very much. The first we have is N1, which did have a modification to it. The modification was just slightly different than what was posted online, and I did see that the new materials are posted online. But this agenda item is specifically to approve the addendum to the initial statement of reasons that was sent out by us to clarify and correct a date on the initial statement of reasons. That is the only action for this item. The additional item that was added was the letter of support from NCARB, which is not required to be reviewed by the board, but we thought it was good for you to see. Do you have any questions for this?
Thank you, Tim. Are there any questions for Mr. Rhoda? Seeing none, we will now go to the public attendees for any public comment.
Do we get the motion first?
Seeing none, I will ask the facilitator to open up the channels to the online participants for public comment.
We are open for public comment on N1. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand. And as a reminder to our mobile device users, you may need to hit the ellipses button. That's the ... in order to find your hand. We're going to take a few seconds to see if we have a request for public comment. Seeing no request for public comment, do you wish to continue?
Yes, please. Thank you very much. I would now ask that our EO basically read the motion.
Sure. If a member wants to make this motion when they're ready, it is to ratify the addendum to the initial statement of reasons for section 116, published during the 15-day comment period, and authorize the executive officer to take all steps necessary to complete the rulemaking process, make any technical or non-substantive changes to the package, and adopt the proposed amendments to section 116.
I so move.
Second.
Been moved and properly second by Member Puriman and second by Member Serrano. Madam Secretary, please call the roll.
Ron Jones,
Yes.
Victoria Brown, present. Tian Feng,
Yeah, presence.
Major Kanani, Leonard Manukian,
Aye.
Robert Pearman,
Aye.
Nilza Serrano,
Aye.
Amanda Stoudemire, Rod Sweet,
Aye.
Sunny Ward.
Thank you. Motion carries. We're now going to an agenda item N2, Mr. Rhoda.
Okay, this one is similar during review of the proposed language that was approved by the board at its December meeting for the reasonable accommodations reg. we needed to change the language from medical disability to mental disability to correctly reference the government code section that was being cited. So we need the board to reapprove the language as we proceed through the process.
Thank you. Are any questions or comments?
I have a comment. Can you, why was the reason for moving from medical to mental?
The government code cited is specifically for mental disabilities. And so we needed to say it was for mental disabilities.
Gotcha. Okay, thank you.
If there aren't any other questions, I'll read the motion this time before we open for public comment, in case anyone wants to comment on the motion. If
Perfect.
you're ready, didn't want to step on anyone's toes. Okay. A motion to approve the modification to the proposed regulatory text for section 124, which was already corrected in text provided in the 45-day notice period, and authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any technical or non-substantive changes to the package, and adopt the proposed regulations at section 124 as noticed.
It's a motion on the floor.
So moved.
Second.
Been moved by member Serrano, seconded by member Pearlman. We will open the floor for public comment for those in attendance. Seeing none, we'll ask the facilitator to open up the public channels online for public comment.
We are open for public comment on the motion. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users, dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a few seconds now to see if we have a request for public comment. Seeing no request for public comment, do you wish to continue with the motion?
Yes, please. Secretary Brass, will you call roll?
Ron Jones,
Yes.
Victoria Brash, present. Leon Fang,
Aye.
Teacher Kanani, Leonard Venusian,
Aye.
Robert Pearman,
Aye.
Ilza Serrano. Aye. Amanda Stillmeyer, Rod Speaks,
Aye.
Sunny Ward.
Thank you. Motion carries. We will now go on to agenda item N.3. Ms. Rhoda.
Thank you very much. This again was a language that was previously approved by the board, but during further review by the department, we had some clarity issues raised and identified. So we have modified the language to clarify that there is not an application, but it is a request that is being made to the board for these application or extensions for eligibility with the board. I have attached the clean language that we will be using and then language with markup identifying the changes that were made. So we need the board to approve this language and we can proceed with the regulatory proposal.
And I would ask the executive officer to read the suggested motion.
A motion to approve the proposed regulatory text for section 109, direct staff to submit the text to the Director of the Department of Consumer Affairs and the Business, Consumer Services and Housing Agency for review, and if no adverse comments are received, authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the package, and set the matter for a hearing if requested. If the board does not receive any comments providing objections or adverse recommendations specifically directed at the proposed action, or to the procedures followed by the board in proposing or adopting the action during the 45-day comment period, and no hearing is requested, then the board authorizes the executive officer to take all steps necessary to initiate the rulemaking process, make any technical or non-substantive changes to the package, and adopt the proposed regulations at section 109 as noticed.
So moved. Serrano.
I'll second.
Been moved by member Serrano, seconded again by member Pearlman. We will open the floor to the public for comment or questions. Seeing none, we will ask the facilitator to open up online channels for public comment.
We are open for public comment on N3 and the motion. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take a few seconds to see if we have a request for public comment. Seeing no request, you wish to continue with the motion?
Yes, please. I'm going to ask Secretary Brass to take roll.
Ron Jones,
Yes.
Victoria Branch, yes. Tion Fang,
yes,
Peter Kanani, Leonard Benukian,
Yes.
Robert Pearman,
Yes.
Nicholas Serrano. Yes. Amanda Stallmeyer, Rod Sleese,
Yes.
Sunny Ward.
Motion carries. Thank you very much. We will now go to item N.4, Mr. Rhoda.
Thank you. This is the last one. This is a brand new proposal regarding the retired license and how to reinstate it to an active license. The proposal we are suggesting is that there be a cooling off period of 1 year before a licensee can try and reinstate their license to active, as well as requiring them to submit proof of continuing education that is mandated to renew the license instead of a statement saying that they have completed. So this will make them be retired licensed for 1 year and then require they submit proof of the continuing education to reinstate their license, if they choose to reinstate their license.
Thank you. I will ask the executive officer to read the suggested motion, please.
I just have a question.
Yes, please.
Please, thank you. So what we're saying is that if I retire from architecture and then 2 years in, I decide I don't like it, retirement is boring, you're going to make me wait a year for me to get my license again?
No, because what we're doing is saying if you retire your license, 1 year from that date is the earliest you can reinstate. You can change your mind.
Okay, that makes sense. Okay, thank you. Thank you for the clarification.
So, I think in the bar, there isn't an active status, but we don't have that in architecture, correct?
Correct. We do not have an inactive license.
And did you find that this issue of people temporarily retiring when they really want to be inactive happened on occasion? It's just theoretical that there's this loophole.
I believe it has happened on occasion.
Yeah, I don't think it's very common, but we did have a substantially higher number of retired licenses than we anticipated. So just was the opportunity to look and see what maybe changes we needed to make to improve the process.
And is it thought here that there may be a buyer's remorse and that the person may retire and then change their mind for whatever reason and decide, I want to reinstate my license? Is that why this is considered?
I believe it's that, and just to ensure that we are meeting well, this was mostly about the continuing education requirement. The 1 year cooling off period, I believe we put on just to make sure, yes, that it is what they want to do. That you are paying this money to retire your license, and that is a status now, and not to just go back and forth as.
And as a point of clarification, beyond that first year, 3 years later, the licensee decides they reconsidered and wants to re-engage. Can you share that process for the purposes of clarification?
Yes, the licensee would submit an application to reinstate their license. They would need to pay the accrued renewal fee and then submit the the required continuing education at the time that they renew their license or want to bring it active, whatever it may be at that time.
Perfect. Thank you. Yes, please.
Is there a required continuing education at this time for those who have active license?
Yes.
And what is it? Just briefly.
I don't recall offhand.
The continuing education requirement? It is, they need every 2 years. So the license is good for 2 years. They need 5 hours in ADA and 5 hours in zero net carbon.
Okay, so if now with this proposed change, if they change their mind within a year, then everything is okay?
Not
But they cannot do it within a year?
Yes.
Okay,
After 1 year, they would need to submit the continuing education and apply for reinstatement.
Okay.
I do need to say that there is still a 5-year limit to bring your license back to active status, even from retired.
All right.
So beyond the 5 years, the license is formally closed.
Yes.
And that will be made very clear to applicants who want to retire their license.
Yes.
So these rules will be, clear to them.
Yes.
Okay.
So after 5 years, you'd have to just reapply like you were a new applicant then, right?
Correct.
And just to answer my question, so if you were subject to disciplinary action, there's no way you can kind of retire as a way to escape it? I mean, if you then try and use this to reactivate, you're still subject to whatever was the penalties before. How would that work?
You are a retired license or even an active license is still subject to discipline.
I mean, if you already had, so whatever was imposed before, it's not abated or told, anything like that, if I'm getting at.
Correct.
You can't use that.
Right.
now.
If they tried to reinstate and maybe they retired when they were in the process, yeah, it would still be there. It'd still be attached to their license.
There would still be the internal review. Thank you.
Just a point of clarification, the regulation does, or the statute does provide that they have to be in good standing before they retire?
I don't recall
I'm
offhand.
actually not sure.
Okay, I'll have to check on that one. Okay.
The answer would be yes. You have to be in good standing.
You do have to be in good standing. Thank you, Marcus. It's a good question.
And I'm sorry, you said this is similar to other professions, like, for example, civil engineers or,
I'm not sure about other professions.
Not everyone has a retired license. We can do a comparison and send you out information if you're interested to see. I don't know offhand who else has it.
I can add that that is a standard to wait the 1 year, and that's typical for any order of the board or any direction. It's for administrative efficiency, so that staff and the board aren't constantly making an order or making a change in license status and then changing it back the next month and then changing it back the next month. And so it is a standard that when there's a change in license status or an order, that there is a 1 year waiting period before a new action can be proposed.
but this is the first time we.
The first time for this board, correct.
Thank you.
So one more last question, sorry for me. What is the fee that we're going to charge them? They're just going to be a regular active fee again for their license to renew?
I didn't change the fee, but it is currently,
A renewal fee is $400. So to reinstate, they'd have to pay.
They'll have to pay that, and
Yeah.
I guess they're retirees have to pay to.
Retirees
retire
pay
their license.
$40 to retire
About
their
40,
license.
and then
Yeah.
now they'll have to, okay,
Right.
gotcha, thank you.
And the $40 is a one-time fee.
And so the cooling off period, if the cooling off period is new for this group, what's the plan to educate or change the paperwork for the retirement process so that the applicants are informed, okay, once you do this, you've got to wait a year?
I do plan on sending out emails and having our website updated to share this information.
We can make sure we send a notice specifically to the people who are retired and that are going to be impacted by this change and make sure we contact them directly.
Oh, great.
But I would imagine that there is an acknowledgement clause even in the application that speaks to these conditions, correct?
Yes,
There
we
will
would
be.
need to update. Once this regulatory proposal goes through, yes, we would need to update the application with these new provisions.
Again, the chair will open the floor for public comment or questions.
I'll just read the motion while we're doing that. If that's all right. This is, okay. Motion to approve the proposed regulatory text for section 109.1. Direct staff to submit the text to the Director of the Department of Consumer Affairs and the Businesses, Consumer Services and Housing Agency for review. And if no adverse comments are received, authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the package, and set the matter for a hearing if requested. If the board does not receive any comments providing objections or adverse recommendations specifically directed at the proposed action, or to the procedures followed by the board in proposing or adopting the action during the 45-day comment period, and no hearing is requested, then the board authorizes the executive officer to take all steps necessary to initiate the rulemaking process, make any technical or non-substantive changes to the package, and adopt the proposed regulations at section 109.1 as noticed.
I so move.
I second.
Okay.
Thank you. Been moved by member Perriman and second by member Squeeze. Now the floor chair will open the floor for public comment or questions. Seeing none, we'll ask the facilitator to open up the online portals for public comment or questions.
We are open for public comment on N4 and the motion. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users, dial *3 to raise your hand. And as a reminder to our mobile device users, you may need to hit the ellipses button, that's the ... in order to find your hand. We're going to take just a few seconds to see if we have a request for public comment. Seeing no request for public comment, do you wish to continue with the motion?
Yes, please. Secretary Brash, will you call roll?
Ron Jones,
Yes.
Victoria Branch, yes. Tian Feng,
Yes.
Mitra Kanani, Leonard Manukian,
Yes.
Robert Pearman,
Yes.
Ilza Serrano,
Yes.
Amanda Stoudemire, Rod Sweets,
Yes.
Sunny Ward.
Thank you. Motion carries. We will now, thank you, Mr. Hoda. Thank you very much. We will now, he was running from the chair then. We'll now go to agenda item I, approval of the board meeting minutes for February 20th, 2025.
Serrano, so moved.
Second.
Been moved by member Serrano, second by member Perriman. Is there any public comment? Seeing none, we will open the portals up to online comments by the public, please.
We are open for public comment on agenda item I and the motion. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users, dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take a few seconds to see if we have a request for public comment. Seeing no request for public comment, do you wish to continue with the motion?
Yes, please. Thank you very much. Secretary Brash, when you take roll, please.
Ron Jones,
Yes.
Victoria Branch, yes. Tian Feng,
Yes.
Mitra Kanani, Leonard Manukian,
Yes.
Robert Pearman,
Yes.
Ilza Serrano,
Yes.
Amanda Stoudemire,
Yes.
Rod Sweets,
Yes.
Sunny Ward.
Thank you very much. Motion carries. We will now go into agenda item E, the budget committee, the budget update from DCA, please. I've been informed that they will be presenting online.
Good morning. Can you hear me?
Yes, sir.
Thank you. Good morning. My name is Luke Fitzgerald. I'm a budget analyst with the DCA Budget Office, and I'm joined by Budget Manager Suzanne Balkus. I'd like to thank the board and executive staff for allowing me a few minutes to present on agenda item E, the board's expenditure projections and fund condition statement. First, I'm going to start with the board expenditures, which is going to be the first page of your materials. These projections are based on actual data through fiscal month 9. This report includes 2023-24 actual expenditures in green, as well as 2024-25 budgeted and projected expenditures in blue and orange. As we move towards the end of the document, you'll see that the board had a beginning base budget of approximately $4,869,000 and is projected to spend approximately $4.5 million, creating a reversion to the board's fund of just under $340,000, or a percentage of 6.94%. The next document I'll be going over is going to be the board's revenue projections, which is on the next page of your materials. This report includes receipts collected through September and projected revenue to year end. And I'll actually go further into these projections as we transition to the next slide. The next page of your materials is going to be the board's fund condition statement. And as a reminder, we read this document from top to bottom and left to right. The left column is going to be the board's prior year 2023-24 actuals. It shows the board began 2023-24 with a beginning balance of $3,003,000, collected $5,679,000 in revenues, with $550,000 from initial license fees, $4,825,000 from license renewals, and $304,000 from the issuance of citations, fines, delinquent fees, and other revenue. The board expended $4,808,000, which includes $425,000 in direct draws to the fund for statewide pro rata and pension payments. The board ended 2023-24 with $3,874,000 in the reserve balance, or about 9.3 months in reserve. For current year 2024-25, the board projects revenues of just over $4 million, with $535,000 projected from initial license fees, $3.3 million from renewal fees, and $183,000 from the issuance of citations, fines, delinquent fees, and other revenue. The board's 2024-25 expenditures are based on fiscal month 9 projections and is just under $5 million between authorized expenditures and direct draws to the fund, leaving the board with a fund balance of approximately $2.9 million, or about 6.8 months in reserve. The Budget Office will continue to monitor the board revenue and expenditures and report back to the board with monthly expenditure projections as we continue to close fiscal months in the current fiscal year. And then just a few things to note on the board's fund condition statement. The fund condition statement is a snapshot in time. One of the main factors driving expenditure increases in future years is a result of personal service adjustments. These include general salary increases, as well as employee compensation and retirement rate adjustments. The Budget Office includes a conservative ongoing 3% increase to expenditures on the fund condition statement to account for these ongoing incremental adjustments. You'll also notice that revenue is projected with the historic high-low trend in the out years. And then lastly, I'd like to note to the board that any future legislation or unanticipated events could result in the board's need for additional resources, which could create cost pressure on the fund. The Budget Office will continue to monitor the board's fund condition statement and keep the line of communication open with the executive staff for any future needs or expectations. Again, thank you for allowing me for the opportunity to present at today's meeting, and I'll now be happy to take any questions.
Are there any questions from the board? Member Sedemeier?
Just out of curiosity, I see that the renewal fees have quite a vacillation between the year to year. Do you have any information behind that? Why does it go up so high and drop down?
Yes, so that's going to be part of the high-low projections that we do, and Suzanne can maybe speak to this a little bit more. But essentially, there are high years and low years, which cause that to fluctuate. So you'll see that there are years where it's projected to be a higher amount, and that's part of the, I believe, biennial renewal process. And so it will cause there to be increases in some years and then decreases in the years, but that's part of what we project for.
The renewal fee is every 2 years.
Thank you. There we go.
It was only in 5 number of years. We
Okay,
just changed our statutes to make it 2 years from date of issuance. So this fluctuation should excuse over time.
okay, that makes more sense. I was expecting it to see, half a group. Okay.
I had the same question when I started on this commission.
A question on the revenue projection report, which is, I guess, the second page of your presentation. What are other regulatory fees which seem to be projected to be, well, not a large amount, double what the budget was?
I'm sorry, can you say for me again?
Under the line item revenue projection report, you have fiscal code, other regulatory fees, budget 24,000, projection to year end 43,840. So what does that mean? Then what does that constitute, and why is it double the budget?
So I think I'm going to defer to Suzanne on this question if she's on.
I don't think that, Suzanne is there. Does she need to be promoted? Nope.
Oh, wait, yes, she does.
If you, moderator, if you could promote Suzanne to a panelist, she should be able to answer this question.
You know what they are.
Hi, can you hear me?
Yes, thank you.
Thank you. So the other regulatory license and permit, these are going to be the exams, applications fees, and retired license, as well as an initial license for architects.
So I guess there's more staff because those things are kind of variable and hard to predict. So that's why it's double the budget, or any sense of that?
So it's not necessarily double. So the current year is based on what we're projected. So it's based on FM10, sorry, in this case, if FM9 actuals, and then what we're projecting. And then budget year is based on what the board is projecting to estimating that they're going to be receiving. And then it fluctuates in budget year +1 for the same purpose as Luke said, because of the biannual. So it will have, you will have the fluctuation.
And the line item FTB site fine collection, a couple of items, projection to year end 1,170. If you know the staff, is that what our collection agencies bring in? Exactly what does that line item mean?
FTB has
that's
it like,
the,
oh, go ahead. Sorry.
Go ahead. It's fine. That's the site and fine. And this is really hard to project for that line item because we don't know what you're going to be, the fines are going to be receiving every single fiscal year. So it is going to be a little bit hard to project. For now, it shows that you are actually just received one FTB in 170 in November. And that's the only one that we're seeing for this fiscal year. And we do not project for the site and fine.
We can get the franchise.
It's like an
tax
intercept
pay.
program, right? If someone doesn't pay their outstanding citation, it can be taken out of their taxes.
Okay, thank you.
I know that there was an impact. We talked about this last time about the revenue that was, the declining revenue that was not anticipated from retired licensees. And so I think, is that reflected in the current numbers that we're seeing? Again, I'm now on the, what page is this? On the last thing that the analysis of fund conditions. Does that kind of speak to the sort of alternating year decline? And for example, if I'm looking at the trend in alternating years, if I'm looking at actuals versus business, actual 2023, 24 to 2025, 26, that pattern is basically about a 15% decline. And then if I do the same thing between 24, 25 and 26, 27, it's about a 30% decline. Is there a pattern is there something to be garnered from that pattern?
Let's wait to see if she spoke. Okay, so I think it's, we have seen, I mean, we've already realized the reduction in the revenue, so that's just impacted in all the numbers because they're not there. But I think the high-low you're seeing there is more in reference to the renewal fees with the peak and the non-peak years. So it's why it's different every year. But so overall, those numbers are just in general lower because of the number of licensees that retired. So revenue would have been higher across the board if they hadn't retired their license, if that makes sense.
Yes. And I guess what I'm questioning is whether or not the declining pattern, even in the alternating years, for example, if I'm looking at 24, 25 and then 26, 27, the pattern isn't maintaining. It's basically dropping. And is there something to be garnered from that? I guess what I'm trying to.
So we typically reassess in the fall. So what we do is, this is just an estimate for now based on previous year's trend. But since now we have the 24, 25, and if we see an increase, then we will reevaluate in the fall with the actuals numbers that we have in 24, 25.
So they should adjust.
So these numbers, you will see that it changed. Yeah, these numbers changes in a yearly basis because it's based on what we're tracking in the past 3 years.
Thank you.
Of course.
Did you have a question? No, but I see no questions from the board. We open the floor for public comment. Seeing none, we'll ask the moderator to open up the audio channels online for public comment or questions.
We are now open for public comment via WebEx on the budget report. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take a few seconds now to see if we have a request for public comment. Seeing no request, do you wish to continue?
Yes, please. Thank you very much. I want to say thank you to Ms. Balkis and Mr. Fitzgerald for their presentation.
Thank you.
Thank you.
We'll now move on to agenda item G, the Bagley-Keene Open Meetings Act training, and that's going to be conducted by Ms. Helen. Pronounce your last name, please.
Joffrey.
Joffrey. Thank you very much.
You're welcome. Thank you very much. So to let everyone know, every member is required to attend what's called board member orientation training when they first become appointed, or within the first year that they're appointed, and within the first year that they are reappointed. However, that training is pretty generic. And so what we do periodically with the boards is also provide a little more detailed information, and as well as give the public an opportunity to kind of review the law that they see most often, and discussed most often during open session. So let me begin. We got my training up. We can go ahead, and there's some resources for you, but we'll skip right on through to the rights of the public. So Article 1, Section 3 of the California Constitution provides that the people have the right to access information concerning the conduct of the people's business. The Constitution provides that the people have a right to instruct their representatives, and the people have the right of access to information concerning the conduct of the people's business. A statute, court rule, or other authority shall be broadly construed if it furthers the people's right to access, and narrowly construed if it limits the right of access. Next slide. To protect these rights, California adopted open meeting laws and procedures because this board, as all boards, commissions, and bureaus, are performing the people's business. The Open Meeting Act that is applied to the California Architects Board is the Bagley-Keene Open Meeting Act. You'll hear me refer to it as Bagley-Keene most of the time. That is my shorthand for it. Sometimes people will call it an OMA or an Open Meeting Act. It begins as follows. It is the public policy of this state that public agencies exist to aid in the conduct of the people's business, and that proceedings of public agencies be conducted openly so that the public may remain informed. It is the intent of the law that actions of state agencies be taken openly, and that their deliberation be conducted openly. The people of the next slide, the people of this state do not yield their sovereignty to the agencies which serve them. The people do not give their public servants the right to decide what is good for the people to know and what is not good for them to know. The people insist upon remaining informed so that they may regain control over the instruments that they have created. Compliance is critical. Board business is the people's business, and they have a right to know what will be discussed, what is decided, and the activities of their government. Members of the board and members and board staff are responsible for ensuring that the people's business is public and accessible to all who wish to participate. The board will be held responsible for violating the public's right to access. The board has three main duties. One, give proper notice of the meeting and items to be discussed. 2, conduct meetings in open session unless closed session is authorized. 3, provide the public the opportunity to comment so that they may engage with their representatives. If we can move to the slide that says, when is a meeting? One more. One more. There we go. A meeting occurs when a majority of the members hear, discuss, or deliberate on topics within the board's jurisdiction. As seen here, subdivision A of Government Code section 11122.5 references when members are all together, such as today. Next slide. Subdivision B references when a series of communications results in a meeting. This happens when members chat along a line where one member talks to another member, or when one person serves as a centerpiece and talks to the other members and receives a consensus. The executive officer, board counsel, and chair are at most risk of accidentally becoming this centerpiece and communicating a consensus of ideas. However, each member and staff must be careful to not discuss positions and opinions of the members to other members, accidentally creating a serial meeting, which would then, of course, not be noticed as required. What is not a meeting? Bagley-Keene does allow for member-to-member communication when the matter is open to the public or purely social in nature. Board business cannot be discussed, however. The Department of Consumer Affairs follows what is known as the Rule of Two. In the Rule of Two, as long as no more than 2 members are present together, it is very clear that neither a majority nor a quorum is created. What is a quorum? A quorum is the minimum number of members that must be present to conduct business. A quorum for a vote counts only those who are entitled to vote of the statutory seats assigned to the board. If a member needs to recuse themselves, they do not count towards the quorum. However, the law does have what's known as the rule of necessity. In this case, if a recused member eliminates the quorum, then the recused member must be brought back, announce the conflict, and remain silent during the discussion so that the board may conduct business with the quorum. The Architects Board quorum. The Architects Board has 10 statutory seats, a majority, and also they have a statutory mandate, but it does happen to be the same as quorum. It is 6 seats, and the board does have special rules for how a vote is passed, where rather than just a majority of those present in the quorum, it has a specific number, and we will discuss that shortly. Before the meeting. Go ahead and move on to the next couple of slides, I think. Next. One more. Behind the scenes. Members are responsible for properly noticed meetings. However, while the members are responsible for making sure they're properly noticed, the executive officer, board staff, board counsel, and even IT division work to make sure that the agenda is compliant with Bagley-Keene. Notice required for all meetings. The notice and agenda must include a brief description of what will be discussed. If it's not on the agenda, it can't be discussed. The discussions must remain within that which would be anticipated as within a notice topic or what was specified on the agenda. So if the topic on the agenda is materials approved to build a wall, various materials may be discussed. If the agenda lists brick walls, wooden walls cannot be discussed. A wooden wall discussion would have to be separately noticed on another agenda. There are 3 types of meeting with corresponding notice. We're just going to go through them briefly. A regular meeting like this one, and typically what this board handles, requires 10 days notice minimum. Special meetings are allowed in the statute for very specific reasons, and they require 48-hour notice. Emergency meetings for very few and very specific reasons under the law require 1-hour notice. For both special meetings and emergency meetings, there also must be an alert to the media. Meetings via webcast or teleconference. This occurs when members are connected via the internet or phone or other electronic means, and the members must attend from a publicly noticed location. Hybrid meetings. Previously, meetings were either in person or fully virtual, and as we just mentioned, that is still an option. However, as of 2024, there are now options for the board to meet with a quorum in person and the remaining members appearing virtually, as we are doing today. Committees can meet fully virtually without noticing their locations, as long as a physical location with at least 1 staff member is available. The public right to privacy within a public board meeting. The public is not required to identify themselves to participate at a meeting. The board may ask, and as you can see, we have a sign-in sheet, and when someone comes up to the front, they can be asked for their name. However, it is not required. ADA compliance. All meetings must be ADA compliant. The board staff ensures that board selected locations meet this criteria. When members appear virtually from a noticed location, the executive officer will work with the member to make sure that that location is also ADA compliant. Meeting materials. The public has a right to access the meeting materials used by the board. Materials prepared for use at the meeting must be published online before the meeting and available at the meeting. Materials introduced at the meeting must be available after the meeting. Open session, general rules. All meetings are open to the public unless specifically authorized. The public must be able to comment on each event, I apologize, on each agenda item, and when in doubt, ask for public comment. On the slide, webcast and teleconference, there's just some tips to make sure that we have quorum at all times. This is particularly useful when we have a telephone meeting and no one can see each other. Via WebEx, it's a little easier to see if quorum is being maintained. And under the new rules, we do have to, all members do have to appear on camera at all times to make sure that we are maintaining quorum. Discussion. This board's pretty good at this, so I will go ahead and just sort of skim through this. But for an orderly meeting, the agenda item is called. If a member needs to recuse, that's where the member will step out, unless the board needs to invoke the rule of necessity. The item is presented and discussed. Once a motion is made, it must be seconded to continue. If a motion is not seconded, that means no one else on the board wishes to entertain that motion and discussion can proceed. Public comment can be called for before any discussion, during the discussion, before a motion, or after a motion. However, it is required that the public must be able to comment before a vote is taken. If public comment stirs substantive board discussion, then public comment must be taken again before the vote commences. Discussion by the members must remain on the notice topic so that the public can follow along and participate. The chair can reopen an agenda item if necessary. However, even if public comment stirs up other topics that are not on the agenda, the members can only discuss what is within the boundaries of the topic notice to make sure that all who wish to participate in a given subject are given that opportunity. Motions. On this slide is some details and steps on how to make a motion. This board is very good at that, so we're going to move on. Ending debate. The chair has the option to end debate on an item when it appears that the topic may need more discussion or more information presented at another meeting, or the discussion is becoming repetitive. Also, to pause or provide insight on debate, public comment can be requested. Then, if a motion is on the table, the chair can also call for a vote. Any member can also do what's called call for the question, which means to stop the discussion and take the vote. This halt in discussion requires a second, public comment, and 2/3 approval by the board to cease discussion and commence a vote immediately. Counting votes. The members may vote to support a motion, oppose the motion, or abstain from the motion. The board requires 5 members to support a motion to pass it, regardless of how many are present, or 6 members when all 10 are present. This means that if we have exactly a quorum or 6 members, 5, not a majority, must support the motion to pass. Recusals. This slide has details regarding recusals, but we can go ahead and skip it unless there's any questions by the members about recusing.
I had a question,
Sure.
but I don't have the slide for me, but just, are there statutes saying when you have to recuse, or is this like the Supreme Court? You do it when you feel it's just individual?
There are statutes and regulations, but they're pretty broad. A vast majority of them focus on whether or not you have a direct conflict or an apparent conflict. For example, if one of the members as part of their outside activities was involved in a association or something, and that association brought a legislation to the the legislature, then if that item comes before the board, the member may need to recuse themselves depending upon how active they were in that. Definitely if there is some kind of purchase or anything like that. I'm trying to think, we actually had one the other day where somebody had to recuse themselves.
I will say, I don't think we've seen it at the board, but for landscape architects, we have had a landscape architect member recuse themselves because that program is responsible for approving an extension certificate program at UCLA. And one or more committee members in the past have served on the faculty of the program, so they recuse themselves from that discussion.
And I did also have a board member who did, her profession was translating. And so there was a bill that came before the boards regarding providing a translator or paying for a translator or something of that nature. So she recused herself just on the caution. So while her business wasn't involved in that, it would directly benefit. And so out of caution, she recused herself. She could have also, since she wasn't directly related, because that's where it starts to get fuzzy. If it's not directly, but the public may think that there might be a conflict, then it's always best to err on the side of caution if we can. But since she had nothing to do with that bill, she could have abstained, but she erred on the side of caution. So there are rules if you directly conflict or if there's an appearance of conflict, but the facts get a little mushy. So usually that's where they reach out either to the executive officer or to me, so we can kind of discuss what might be the best option. And if the member does feel that there's a doubt, then it's usually safest to recuse. Okay, any other questions about recusals?
I didn't have a question about recusals, but I did have a question about, I don't know if you want to go backwards or you want to.
We can. I was going to see if we had questions at the end, but if you'd like to ask now, we can ask now.
We're
Okay,
waiting for the end anyway, so go ahead.
sure. So public comment. When in doubt, ask for public comment. However, a reasonable time limit can be set for public comments. That's usually on the agenda, but it can be set by the chair at the time. Items not on the agenda. While the members may not discuss items on the agenda, the public has a right to raise topics outside of the agenda. These topics cannot be discussed by the board until noticed on a future meeting. The board can only discuss and possibly vote if it wishes to have the matter set on a future agenda, but that's the only discussion that is permitted. The public can raise information of interest, topics for future agendas, or anything of relevance to the jurisdiction of the board. Items not on the agenda. Also, when the public makes a comment, the chair also has the option to either refer the member to contact staff for information, because sometimes the comment is more or less a question, or they can coordinate later with the executive officer to add the item to the agenda. So the board is not required to discuss and vote as to whether or not they want it on a future agenda. The chair and the executive officer can handle that. However, if the board is very adamant they would like it, they can certainly do so. Disorderly conduct. Public meetings are for the public's business, but it must serve all of the public. Willfully disrupting the meeting is not acceptable. The board cannot prevent criticism and must protect the right of the public to comment. However, the board must also maintain order and must protect the public against profane comments. The board must also protect due process and privacy by not allowing discussion on current enforcement matters. Disruptive persons. To minimize aggressive or irrelevant comments, the chair may request the person to speak more slowly and refrain from inappropriate language, terminate the individual's public comment, request the person leave the room, put the meeting in a recess, or terminate the meeting. Technical disruptions. It's a matter of when, not if, technical issues will arise. And so this and the next slide are options to minimize or deal with technical issues, but not necessary to read through today. Unique meetings. Special and emergency meetings are rare, so this information on these slides would need to be reviewed again if one happened, and that's pretty standard across DCA. We rarely have special or emergency meetings, so we always have to review. But if you have any questions at the end on this, I'm also happy to answer that as well. Closed session. In conducting the people's business, everything unless specifically authorized must be deliberated in open session. Most of the closed sessions items are done for privacy of the person involved, such as the licensee subject to discipline or the executive officer during their review. Exam issues are also private to maintain the integrity of the exam, and pending litigation requires legal advice and strategy development. Closed session agenda. Even though closed session is not for public attendance, the public still has a right to know what the board is doing. Closed session is also limited to what is on the agenda. To have a closed session, it must be noticed on the agenda with the specific statutory provision that permits each closed session issue to be discussed, or the board may not proceed. Closed session reporting. Discussions in closed session stay in closed session, but decisions reached in closed session do become public information. Discipline is either posted or eliminated as applicable, and action regarding the executive officer's employment with the board must be announced at the next session. Are there any questions on Bagley-Keene from the board?
I actually just had one question.
Absolutely.
You mentioned that in the event of an emergency meeting, we had to notify the media. In what form is that typically done?
So it's for special and for emergency meetings. And I've not seen DCA have an emergency meeting. There's only like two. One of them is work stoppage and natural disaster or something. But for both, the media is alerted by, let me see if it lists in the statute. But I think we call or send a teletype. What do we do? Do you know?
And is it just to all media, or I can just call the Sacramento Bee and have satisfied that requirement?
I believe it's to all media, but let me,
It is an interesting question.
Yeah.
Hopefully we don't, doesn't come up, but I can check because that, would be good to know if we need it, because we wouldn't
Yeah.
want to find out at the time. We'd want to know in advance how to do it.
yeah, exactly. So that's what I'm saying. So we have, I have had a couple boards do it, and since I'm not the one who actually does it, I just tell them they have to do that. Let's see. But yeah, when I first read that in the statute, I was like, ooh. Oh, you know what? No wonder I can't find it. I'm in the wrong.
And while you're doing that,
Absolutely.
the chair will open the floor for any questions or comments from the board. Seeing none, the chair will open up the floor for public comment or questions. Seeing none, the chair will ask that the moderator open up the online portal for public comment or questions.
We are open for public comment on the presentation for the Bagley-Keene Act. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a few seconds now to see if we have a request for public comment. Seeing no request, you wish to continue with the agenda?
Yes, please. Thank you very much.
And it looks like the statute says, quote, notice shall be made available to newspapers of general circulation and radio or television stations.
Plural.
So, yes. So someone's
Yes.
going to be on the phone.
Really big.
But, and that may need to be updated now that we're looking at it. But, so yeah, it has been done before. It's not often. And usually we try to, as much as possible, provide the 10 days notice. No one wants a 48-hour meeting, or little, somewhere between 10 and 48 if we can avoid it.
Thank you.
Okay.
So if it's okay, I mean, technically we should go back to public comment because you said that after.
I don't know that that's substantive and that is in the law. It's always a good time for public comment. But I don't know that it's substantive enough to necessitate, but
I'm going,
that's certainly up to you.
no, I will pass and I will remove the agenda and we
Okay.
go on to the enforcement and overview training, please.
So for this, we have Helen, you're starting with the training, and then we have some specific to the board, or do you not I can't remember.
I have due process, so I don't know if you would like to do due process first or general enforcement first.
I'll defer to you.
I will go ahead and take due process since I am already on the mic.
And if I could, this deck, neither of these decks are in our package, correct?
They should be.
They may not have been available when we compiled the packet. They are available online, but I will email them out.
Okay, thank
Sorry.
you.
Thank you.
Okay, due process, what does it require? Once the board has given a license to someone, it cannot take it away on impulse. Before the license can be revoked or other discipline issued, the licensee must be fully informed about the reasons of the board's action, options regarding the action, and how the licensee can provide defenses or additional information. Who is involved? When all is well, the architect's board functions as a whole. The members, executive officer, and all staff coordinate in harmony with the licensees. When there is an enforcement issue, this whole becomes split. The board becomes the final decision maker, like a judge. The executive officer and enforcement staff become the complainant, or like a prosecutor. And the licensee or applicant becomes the responding party, like a defendant. Just like in court, neither the complainant prosecutor or respondent defendant can talk to the board judge without both parties being present. The board judge must remain neutral, and neither party can have the advantage of giving the judge additional information behind the other's back. As board counsel, I also become isolated to legally advise the board. The executive officer and enforcement staff are represented by the Deputy Attorney General. Because the board is not an actual panel of judges versed in evidence rules, the matter is heard by an administrative law judge who weighs and takes evidence and then prepares a decision for the board judge to evaluate. Notice and the opportunity to be heard. An accusation is for discipline against a current licensee. A statement of issues is created, when an applicant is denied a license and wants to appeal that denial. We'll call both of these actions. When an action is filed, the Deputy Attorney General must send the action as well as other information and the suggested form to file an appeal to the licensee's address of record. This is why licensees must keep their address of record current. Once a complete action is put in the mail to the address of record, the licensee is effectively served. The licensee has 15 days from the service to request a hearing. The licensee does have the right to accept the discipline proposed. However, if the licensee believes the discipline is in error, they can file a notice of defense. If a notice of defense is submitted within 15 days, the licensee is entitled to a hearing. On the 16th day and every day after that, as far as the board knows, the licensee has accepted the discipline and may proceed. After this time, the licensee can still request a hearing, but it is now at the discretion of the board to grant one. How cases are resolved. Once an accusation is filed, if the licensee files a notice of defense, the licensee defendant and executive officer prosecutor have two options. They can attempt to settle the case so that they are both satisfied with the outcome, or they can go to hearing and let the administrative judge decide. If the licensee does not respond, that case is handled as a default. Stipulated settlement. In a stipulated settlement, often referred to as a STIP, the Deputy Attorney General and the licensee develop a resolution. This can be anything from the executive officer withdrawing the case to an agreement to surrender the license. Statute and the terms and conditions of the STIP permit the Deputy Attorney General and staff to answer any questions the board has about the STIP, but only in support of the agreement that the parties reached. Options. Once the parties agree to the terms, the Deputy Attorney General and the licensee sign the agreement and submit it to the board for review. The board may approve the STIP as is or deny it and send it back to the parties for discussion. The board can also give preferred terms that the Deputy Attorney General can use to issue a counteroffer. If the parties can no longer agree after this, the matter proceeds to hearing. An administrative hearing. An administrative law judge allows both sides to present argument and evidence. The licensee may represent themselves or hire an attorney at their own expense. The proposed decision. In a discipline case against a current licensee, the board has the burden to prove that the license requires discipline by clear and convincing evidence. This is not quite as high as the criminal beyond a reasonable doubt standard, but it is a high standard. Architects have dedicated their lives to their profession, so a lower standard of more likely is not appropriate. The administrative law judge makes sure that the board has presented and proved their case with a high likelihood of truth. Costs for investigation and discipline against a licensee is paid for by licensing fees. To minimize the impact on licensing fees by a licensee who has violated the standards that all licensees must follow, the law permits the board to collect reasonable reimbursement costs from the disciplined licensee to return it back to the board fund. If the board fails to meet its burden and the case is dismissed, the board will not get reimbursed. When an applicant applies for a license, but the staff believes the requirements are not met, the license is denied. If the applicant believes the denial is in error, a statement of issues is submitted. The board is not obligated to give a license to anyone who does not meet standards. Therefore, it is the applicant who has the burden to prove that they are appropriate for licensure. However, the burden here is lower. The applicant must prove that they are more likely than not correct in their arguments against the board's denial. If the applicant is successful in asserting that they are appropriate for licensure, a proposed decision by the administrative law judge can recommend that the board issue the license outright or issue a license on probation to monitor the applicant while licensed, to make sure that the applicant can appropriately practice architecture. You are currently on the collect slide for the one I'm about to start. I got a message asking which slide are we on. After the meeting, the administrative law judge drafts a proposed decision in a format that the board can adopt as is for its decision. Government Code Section 11517 then provides the board's options on how to use the proposed decision in the board's actual decision. The board may adopt the proposed decision as is, make minor changes that do not change the factual or legal findings, reduce the proposed penalty, Reject the matter and have the board review the record, giving the parties the opportunity to provide additional argument. Or reject and remand the proposed decision back to the administrative law judge to take additional evidence. In both the review of the record or the remand back to the administrative judge, the transcript is ordered and available for all parties unless the parties waive the transcript. It also does not mean that the board will change the order, but that either an order may be present or additional information is needed before the board can feel confident in issuing a decision. It is also the only way that the proposed decision may be increased. A default decision. When the respondent does not appeal the action, or if the respondent does appeal but fails to appear at the scheduled hearing with the administrative law judge, the case can be decided as a default decision. The matter is reviewed for full compliance with due process, notice, and the opportunity to be heard. Then the board can order a default decision, meaning the highest level of notice discipline may be issued and the matter closed. Petitions after a decision. Once a decision is issued, due process is still in play for a tad longer. However, the burden of argument is shifting to the respondent and the board's discretion. There is a slide that kind of gives a brief summary of the different types of petitions that the board can see, but we're going to move on to details. So petition to vacate. A respondent has 7 days, just 7 days, to request to vacate a default decision. A default decision means that the respondent hasn't participated in this matter, but now the respondent wants to participate after a decision is issued. The respondent must show good cause to reopen the case by statute. Good cause does include that the respondent does not receive the action. However, that is not because the respondent failed to update their address of record. Licensees have a requirement to keep the address updated, so it is not good cause to reverse a default decision because another law has been violated. However, if the licensee submitted a change in address and the board failed to update that address, that may be a basis. The petition to vacate can include proof that good cause exists for the board to evaluate in its decision as to whether or not to reopen the matter. The board has full discretion to accept the arguments as good cause and reopen the case, or let the default stand. Petition for reconsideration. For proposed decision, the respondent has 30 days or until the decision is effective, whichever is shorter, to petition the board to reconsider its decision. Reiterating the case presented to the administrative law judge is usually not enough to justify a change in the board's decision, as that information was evaluated and evidence laws applied. Petitions to modify or reinstate. After no less than 1 year after a decision is issued, respondents that were disciplined but not revoked may petition for a modification or early termination of penalty. The licensee has the burden to prove that a lower penalty is appropriate, and the board has full discretion in its decision. If a licensee was revoked, after no less than 1 year, the former licensee may petition to reinstate their license up to 5 years, after the revocation. Oh, wait, I take that back. That may not be accurate. It may be 5 years after a license is otherwise set, but they cannot petition any less than 1 year. The former licensee does have the burden to prove that they are appropriate to return to practicing architecture, and the board has full discretion in its decision to return the license back to the former licensee. Are there any questions on due process from the board? Yes.
In the text, when it refers to days, is that calendar days or business days?
I'm sorry, what?
When it refers to days, the deadline's 30, is it business or calendar?
So I believe the default is calendar, but the statutes just say days.
Yeah.
So that's what I say. But yeah, I do believe when we go through, we do it by calendar. And then it's usually, especially for the 100 days before a decision is reached, if the board does not make one on a proposed decision, we count calendar days for the benefit of the licensee. But yeah, I do believe it is calendar days.
Are there any other questions or comments?
Are there any questions from board members online?
No questions.
Then we'll open up the floor for public comment. Seeing none, we'll ask the moderator to open up the online portals for public comment or questions.
We are now taking public comment via WebEx. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take a few seconds now to see if we have a request for public comment. Seeing no request, you wish to continue with the agenda?
Yes, please. We'll now open up to Laura.
Thank you, Helen. Now we'll have some enforcement information specific to our program. This is Mike Skenga, our lead enforcement analyst.
Good morning,
Good morning.
President. Members of the board. How's that? Better? All right. This looks a little bit like my slides, but these are not exactly my slides. So I will do the best I can. We had a regulatory enforcement committee meeting last month on May 8th and discussed one of the strategic plan objectives, which is to provide more detailed training to board members, staff, and subject matter experts. We talked about ways to do that and came up with the idea that we would give an overview training once every few years or when there are new board members, and then at additional board meetings, give more detailed discussions of enforcement issues. So today I'm going to discuss an overview of the enforcement process. It'll interlink with some of the things that Helen presented. And at the end, you can tell me what you think would be good to focus in on at the next board meeting or two. And I have some proposals for that as well. So in this presentation, I'm going to, after a brief introduction, talk about the intake process for how we get complaints, how we analyze those complaints, what sorts of actions we can take on complaints, and what those outcomes look like. Next slide, please. So this is, back one more. This is your enforcement unit. Program manager is Alicia Krager. I'm the lead enforcement analyst, Michael Skanga. We have two other enforcement analysts, Jasmine Steinwert and Katie Wiley, who have been with us for quite a while. I've been with the board since 2019. Katie was with us before that. We have had very little, but recent turnover. We have a couple of longstanding technicians and one analyst left recently. We now have replaced the technicians with Natalia Diaz and Ryan Riddell. We still have an open analyst position. We're working on getting that filled. You all know Bob Chase. He is our architect consultant. He works very closely with the enforcement unit and meets with us weekly. We have 2 meetings a week to talk about cases. Bob joins us on one of those. We also have currently about half a dozen subject matter experts. We just sent out an announcement you probably saw for applications. The application deadline has passed and we've got about 150 applications to go through. So we're very happy about that. We should be able to find probably another 10 or 20 to proceed with. Next slide, please. So the first step of the enforcement process is case intake. I'm going to talk about where we get cases and what we do with those as they get assigned out. The next slide, please. Cases generally come from consumers. They come from architects. They come from all different sources. These are the different methods we have. We don't get many by fax, but we do get probably 1 or 2 a year by fax. We have a CAB email address. We have a CAB portal, which includes enforcement. There's a DCA portal. Connect itself has a portal which just went active for complaints earlier this year, and a lot of people are using that. We're happy to see. We also get referrals from other agencies. We also open cases based on information we receive in applications and renewals. And architects are also required to report settlements of cases to us over $5,000. So that's another source of cases. Next slide, please. So the first step, once we receive it, is to do a preliminary review to see if it's a case that we can actually do anything with. So we need to actually have a subject. We can't really take action against a business, so we need to at least have a business owner name. They have to be generally in the United States. We've talked recently about how there are apparently a lot of offshore people sending spam to architects, offering services which would technically be in violation, but would be very difficult for us to enforce in another country. So we take some efforts, but generally cannot do a full case based on that. Like I mentioned, complaints can be from clients, building officials, architects. People can submit anonymous complaints, which means they don't hear back from us. They can submit confidential complaints, which means they hear back from us with updates, but we don't tell the subject who filed the complaint. There are some jurisdictional limitations. So when we first get a case, we have to be able to say that we have that this is a potential violation of the Architects Practice Act. That's the other APA. Architects Practice Act violation, and not an architect kicked my dog or something like that. There are statute of limitations in BPC 5561. Generally, we have to take action within 5 years after receiving the complaint and no more than 10 years after the act or omission. So generally, we see that as when construction happened on a project. So if it's longer than 10 years, we lose jurisdiction over that. Next slide, please. Once we're able to establish all of that, it gets assigned out to one of the analysts or technicians that I mentioned. We all have kind of our specialties. We have Ryan specializes in advertising violations. So where an unlicensed person is either calling themselves an architect or offering services generally online that would require a license when they don't have one. Unlicensed practice is similar, but we have a project that we know that the person was involved in. Professional misconduct of licensees. We also have, we follow up on convictions from notice from the DOJ that a candidate for licensure has done their fingerprints and they had a conviction within a certain period of time. We also do the same thing for renewals. When you do a renewal, you have to check off whether you have been disciplined by another agency or you've had a conviction. We follow up on those. We also follow up on cases of architects receiving discipline either in another state or in another California agency like CSLB. And then again, we receive the settlement reports. And so we have different people that kind of specialize in each of those, but those are the different kinds of cases. Those actually all have different folder colors, for example. Okay, so then the next step is for that analyst to start their analysis. The next slide, please. So the first thing they'll do is confirm that there is a potential violation which has already been generally identified during intake, but at the beginning of the analysis, it's looked at freshly. Start collecting documents. Usually the complaints include documents, but the most important documents are the architectural services contracts, for example. Then they do further investigation, follow up with either the complainant, the subject, or witnesses. Finally, they finish their analysis. If there is action to be taken, there's an analysis of penalty considerations. Finally, we make a written recommendation that goes to management before any enforcement action is taken. And I'll, in more detail, start in the next slide. So again, we look at the Architects Practice Act, the elements of each of those violations. Documents include statements from each of the parties. This can be either an architect or an unlicensed person. The contract for either one of them is going to be important because there's a lot of unlicensed people that are using contracts that imply that they're an architect. We look at the invoices because a lot of them involve fee disputes. We collect the design plans that the architect has produced. Generally, in case of allegation of negligence, we're going to show those to our subject matter experts. And then now everything is in email, text, so we get a lot of information from the communications between the parties. And a lot of information also, some information, I'll say, from court documents. So a lot of people will file a lawsuit and then send us their civil complaint and ask us to follow up on that. But as you probably know, civil complaints, not necessarily the most reliable source of detailed information. Next slide, please. After the evidence is collected, we conduct interviews with the parties. If it's a matter of professional standard of care, we'll send it to a SME, subject matter expert, for their opinion on that. We can also use the Division of Investigation. They have sworn officers. So if we want to do something like a sting operation to see if we can, get a unlicensed person to promise to do a new commercial project that they're not allowed to do, for example. DFI, they love doing that kind of stuff. And a lot of our statutes do include criminal penalties. So if it's bad enough, or especially if we have repeat offenders, we will send them either through DFI or directly to the local district attorney for consideration. When we consider potential penalties to recommend to management, the biggest ones are consumer harm. Cooperation obviously tells us a lot about whether the person is going to continue misbehavior. There's a whole list of aggravating and mitigating factors in California Code of Regulations, Section 152, that we also consider. But consumer harm, obviously, the ultimate, and their record, if they have past cases with us, we'll look at that. Then the analyst produces a desk investigation report and a recommendation to management of whether action should be taken and what the penalty should be. If there is further formal action, that might go to the Deputy Attorney General in charge of the case. So let me talk a little bit on the next slide about the types of enforcement actions that cases can result in. So sometimes they can just be closed, and I'll go through a little more detail of these, but some closed without a lot of action. There's a level that we issue letters of advisement or warnings to licensed architects. And then there's a level where either unlicensed people or licensees can receive citations with a fine amount. And I know you've seen some of those proposed decisions for those, because they're also entitled to an administrative hearing. Goes through a process very much like a disciplinary action. And then again, they can be disciplined through an accusation or denied a license, as Helen discussed. So the next slide, please. Gives you a little more detail of the different kinds of ways that we close cases. So we can close cases we find that there was no violation, for example, or the violation wasn't something of the Architects Practice Act. There can be insufficient evidence, and it's evidence that we will not be able to get. So we'll close a case either because of insufficient evidence, or like I mentioned before, a lot of attorneys would like to use us to do their investigation. So they send us their civil cases. If they're pending litigation, we really don't want to get too deeply involved in it because it could obviously impact different sides, but also because we're not going to get the full story from either side, and we don't want to interfere with the attorney-client communications. So we close a lot of those cases under the insufficient evidence code. Also, CC 26 is another code that we enter, and these are all codes that are important because when you get your statistics about how we close cases, this is how they're recorded. If, especially in advertising cases, they are quick to respond and fix their violation, then we can close it as cease and desist compliant without issuing a citation. Frequently, we do have cases with no jurisdiction, which might be that the only thing a unlicensed person did was not a violation of the Architects Practice Act, but maybe they were just a bad designer. We don't really have jurisdiction over that. We can issue a letter of advisement. It's to a unlicensed person, or a letter of warning to a licensed person, essentially more strict letter saying this is going to be on your record. If we get any more complaints about this, we'll take all action that we can. And then there's the citation level and the discipline level. Citations, we need to create a document that you've seen, the citation with the findings of the fact that the board has made and that management has approved. There's a whole process that has to be followed for serving that on either a licensee through their address of record or an unlicensed person, which can be difficult. Once a person receives a citation, in our board, they're entitled to an informal conference. So we set up a teleconference with the enforcement staff that worked on the case, and also management and Laura. And they have an opportunity to provide any additional information that was not brought up in the investigation. And it's an opportunity to sometimes mediate or mitigate their violation. And sometimes we lower the fines after that. It's not really like a settlement conference. It's more an opportunity for them to speak to management and say, here's what you missed. Citations are also entitled to administrative hearing after the informal conference, using the same procedures that Helen mentioned. And if they want to appeal that decision, they have to go to the Superior Court. Disciplinary actions and denial of license applications go to the Attorney General's office, and they file the accusation or statement of information. Again, that goes through service on the address of record. There's an opportunity for settlement, otherwise administrative hearing and a Superior Court writ, as we discussed before. Next page, please. So here's the outcomes, how you and the public see the results of our work. And I've passed out some of our publications. And to respond to Helen's question, all of the publications are in here. I brought extra copies, or all of this information is in the last REC meeting packet. So we discussed this in much more detail at the REC meeting, which I think went on for close to 5 hours. And so all of these documents that I'm discussing today are in that packet if you'd like to look at more detail. So you see the statistics of which kinds of cases we have and how they're settled. You see the summaries of the cases, individual cases. You see that go to citation or discipline. If you're in a closed session, you might review the proposed decisions of a judge. Sometimes you review settlements. On the other hand, the executive officer also has that power in some kinds of cases. We also generate disciplinary guidelines that are used by the judges and by you in closed session. The public also sees the summaries. Those are posted on our website. You can also, there's a DCA website where you can look up a license that also has links to the documents from a case. So public documents from our cases include only the final citation or accusation or order of the board. It does not include our investigatory materials, even though we do get asked for that a lot through CPRA requests. We put together a large number of informational bulletins based on the information that we find from our investigations. And so you'll see those also on our website. I've given you a copy of the little red book. It's called the Building Officials Information Guide, which is kind of a compendium of all of the informational bulletins and our opinions and guidance on the Architects Practice Act, which I think is very helpful and has to be updated every few years because the Architects Practice Act does change. And then on the next page, I'll show you the strategic plan objective. That I've been trying to address. We want to provide additional training to our experts, and we will have a training session once we hire some new SMEs. Obviously, we want you board members to be prepared to understand the summaries and other information that we give you, and also understand in detail the proposed decisions that you're receiving. And we also want staff of the board, who hopefully some of them are watching, to understand better what goes on in the enforcement unit at our office. So I will suggest we do have an informational bulletin called Responsible Control in Design, Build, and Design Firms, which has a lot of really detailed and important information about third-party relationships and contracts between architects and developers and insurance companies and their clients. We discussed this in some detail at the REC meeting, but it is all filtered down to a nice informational bulletin. I would suggest that that's your homework, and that at our next board meeting, we discuss that in some more detail. But if there's anything else that you think would be interesting or helpful to you, let me know and we'll put something together. Next slide. Thank you.
Thank you very much. Cheryl, any comment from the board?
I have questions. Oh, go
There's
ahead.
a lot.
I have a quick one. Do we have any information on the most common violations of the Practice Act?
I'm so glad you asked. We just published that yesterday. It's on our website. We have a list. Now, there is a list of them in the EO report, which I think is upcoming, but we just published a bulletin yesterday that has details of each one and what the violations are, what the statutes are that are involved.
I'll send that link out to members.
Great. I think it's great that we're providing that to the profession so that they can, keep an eye out on how to, stay in line. So.
Thank you.
My question is, does the enforcement department is it getting prepared for the influx of complaints that you're going to get after the Eaton and fires and the Palisades, 16,000 homes? Many people are going to be extra disappointed in anything that goes wrong. Is the system prepared for that?
So we hope so. We're trying. So we have already done a lot of work on unlawful advertising to fire victims. And there's actually a specific statute that increases penalties for unlawful practice and advertising in a state of emergency. We've already had a few of those cases. We've got some outreach. I'm actually giving a presentation with AIA California on the 17th about considerations that fire victims should be aware of when hiring an architect. I think it's going to be interesting because they have kind of changed some of the rules locally for submission and that sort of thing. So we'll see if the architects can deal with that and if the unlicensed people can deal with that. Our team has been present for other natural disasters and we did the same thing, outreach. We did get more cases and we've dealt with it. So we're hoping, I think you're right that it's going to be, it's unpredictable, but we're doing our best.
Thank you. I appreciate your presentation.
On the case intake, it mentioned applications, DOJ, FBI. Now, is that just from the fingerprinting or is there some other way that you get cases from those agencies?
So on applications, I'm referring to the fingerprinting program for candidates. When they do their fingerprints go to California DOJ and federal FBI for a criminal record. If there's a hit, there's a rap sheet, they send that to us and we review that for whether it is related to the practice of architecture. On the renewals, similarly, you guys don't have to be fingerprinted, but you have to check off a box that says you've been convicted or disciplined. And so that's what the difference is.
On the problem with foreign, I guess, unlicensed practitioners, just a thought or question, maybe not for you, for Laura, where we have these mutual recognition treaties, does that give us either a formal or informal way to get some assistance in prosecution if they come from that jurisdiction?
So if they get licensed through a mutual recognition agreement in California, they're still subject to our requirements in practicing here. I don't know that we've ever had to discipline anyone that became licensed that way. I could check on that. I'm sure NCAR would be able to assist us if needed.
I was thinking more of the unlicensed people that gives us some access to like that government or something like that to do anything. No, it doesn't.
It does not.
Formally,
We
okay.
do open cases against, for example, a Florida architect that's advertising in California that they are an architect. But the ones that are most difficult that I alluded to are generally scams, and they're from other countries or they're from LLCs within this country that are just nearly impossible for us to follow up on.
On the analysis you do where you mentioned consumer harm, explain more to me what that means from your standpoint. Is it just the consumer who's complaining? Is it potential consumers? How do you define that as a factor in your sanctions decisions?
So both. Obviously, their response to us is an indication of whether they're going to continue to be a threat to consumers. But we also look directly at how much they have cost their client and what sort of threat to safety they have created in the particular project that we're investigating.
Are there statutes or regs that clearly articulate that factor is something to be considered and would give, more discipline or sanction if there is more consumer harm versus less, or is it just more judgment call?
So CCR 152 includes that in justifications for raising fines from a maximum of $2,500 to a maximum of $5,000.
Okay. And you mentioned with the unlicensed, we just have this letter of advisement policy. Basically, do other professions being regulated have any more stronger remedies against unlicensed people than we have? Or is it all about the same across the board from your understanding?
I would say, just from my limited experience, that some other agencies like CSLB might be more stringent about that. If you are, practicing without a license, for example, I've seen a lot of cases get referred to for criminal charges. But for us, I mean, it's usually because regulating the word architect is a strange concept for a lot of people, and we recognize that. So if it's an advertising violation and they say, oh, I didn't know I couldn't use that word, and if they're not licensed, why would they know that? We give them a strong warning and say, cease and desist. And I mean, it's not across the board. It's not, always, but depending on their response to us, depending on consumer harm, those sorts of things, that's one of our options.
We can issue citations as well to the unlicensed individual. So if it's a repeat case of that, or if there is some evidence of harm. So it's not the only option. It's just something we will do on a case by case basis.
Okay, my last question for you, or maybe Helen, is when you mentioned maybe holding off on a case because there's pending litigation, that can go 3 or 4 years. So is there a statute of limitations issue if we do that, and you get tolling agreements or the equivalent? How does that work in this case?
It's hard because but we do know that they have representation. So we know that their direct harm is being addressed and they have, somebody working on their behalf. We hate to get involved because if we do that, we're going to start getting subpoenaed to court cases and depositions. And so that's kind of our thinking. So it's optional for us, but it's often not the best idea. If it's complex litigation and it looks like they're just trying to gain leverage by being able to tell the other side that the California Architects Board is investigating them. In those cases, even though they might be really well represented, we're probably just going to monitor it. And then if it's an architect and there's a settlement or a judgment against them, they'll have to report it at that time, and then we can do a complete investigation based on the new evidence that's gathered at the hearing, at the trial.
So there's no, what I call statute of limitations issue there, because you'd be acting on the findings that came out 3 years after the incident when the case was resolved. Is that true?
I have in 5561 that there is a statute of limitations of 5 years, but not more than 10 years. So there is some wiggle room for the for litigation to proceed. I don't know about, I will certainly defer to Mr. Senga, but I know generally that public safety is also weighed. So we do not want to become involved, but if this is a severe harm, then we can. And then, of course, once we wait for civil litigation or criminal litigation to proceed, we can also use that as evidence in our own license issue. So sometimes if it is severe enough, we can step forward, but it benefits us to wait as well. But yeah, it looks like your particular board, some boards have statute of limitations, some do not. So it looks like yours is pretty broad, but there is one.
Yeah, 5 years should cover most cases. All right, thanks. And just to reiterate, as we had discussed at the rec meeting about doing this, so we appreciate Mike and the department taking the lead and doing it right away, because I think everybody would like to see this periodically done.
Thank you.
Yeah, thank you, Michael. I do have a few questions. I think my first question is sort of the disconnect between our regulations in the document you share with me with the Building Officials Information Guide. How do we build better synergy with jurisdictions? For example, I served as a planning commissioner, and we had incidents where unlicensed individuals submitted documents for entitlements. But the city basically was of the opinion that you weren't required to be a licensed individual to do so. I communicated with our board and our staff, and we've shared that information with the jurisdiction, and they still believe that an unlicensed person can still submit entitlement packages, not construction documents, but entitlement packages for projects that an unlicensed individual is prohibited from designing. So how do we bridge that gap?
So it's actually another one of our strategic plan objectives to address that very issue. And we're working on it. One of the steps we're going to take is entering into dialogue with the planning department organization. I can't remember the name of them. But there's an organization of planning departments in California that I think would be interested in sharing their thoughts on it. But it all comes down to the fact that the design of things that are not exempt is illegal. But the statute that tells building departments to verify licensure in those cases does not apply to planning departments for whatever reason. So that's one way to address it, is to fix that legislative loophole. But we would like to gather some information from planning departments to address what you said about, do they really think that it's okay for them to be approving plans from unlicensed people that would require a license?
But there could also be legislation that changes the language of the requirements as well, correct?
Correct.
Okay. The second question is basically in the investigatory process, how do we basically, or how is objective standards and subjective standards managed? For example, contracts are clear. There are eight standards that you have to demonstrate in your contracts. That's objective. You do those things, you're fine. There are subjective standards. And so, for example, if one person is submitting a set of construction documents to a jurisdiction, once the jurisdiction approves those documents, does that basically mean that they've satisfied the subjective standard of service? And so when a subject matter expert reviews documents, one person has one level of documentation, another has another one, but they were both approved by the same jurisdiction. Is it possible that the subject matter expert may think that this person has been lacking in their services, even though they both approved for construction?
Yes.
And so
it doesn't happen a lot, but we do have independent review over the standard of care. So just because something is approved by the building department does not necessarily mean that the architect was not negligent in some other way.
But that would be a subjective standard.
That would be an expert opinion.
Right. But I mean, you have 125 applicants, and so it's an expert opinion. But I guess my question then becomes, is that conversation a collective, meaning a committee of subject matter experts who are evaluating this particular case, or is it one person's determination?
It's usually one subject matter expert subject to the review by the enforcement unit, including our architect consultant.
Okay.
So, I mean, there's only so much we can do. If it makes sense, if it looks like we can proceed on it, if the attorney general agrees, all those things go into it. But it's possible, unlikely that, I mean, you know, we also reason otherwise, that if it was approved, then that is also evidence that it wasn't negligent, but it's not conclusive.
Okay, thank you.
I can also add a little bit to that as well. As he discussed, if the subject matter expert and the approval and the staff all believe that it works, it still is reviewed by the Deputy Attorney General. And then, of course, that's why us lawyers get paid all the money, is because everyone's going to argue. There is also a provision for reasonable costs. If the respondent brings really good arguments that are reasonable but ultimately fail, the cost can be lowered that the person has to pay, because that was potentially legitimate position, even if it was ultimately incorrect. So there are multiple layers of argument and safety to try to ensure that the discipline is not punitive but appropriate.
And I guess my perspective is that, and I use this in my office all the time, is that you can pay $10,000 for a car or $100,000 for a car, but they both perform. They just have different features. And so oftentimes I'm always wondering whether or not the analysis is relevant to the application. And so that would always be my question when I'm looking at conditions like this, is that are the scope of services really equal relative to the fees that have been assigned, because they both performed, they both were satisfied. So it's this gray area that I'm trying to basically reconcile.
I might be able to add a little bit more to that. This particular profession is also, there's a lot of gray area. So we enforce the Practice Act, which has a few fuzzy areas on professional conduct, fraud and whatnot that have some guidance, but may not be you did this, you did not, kind of like with the contract. But also there's a lot of subjective areas that wouldn't necessarily even be within the board's jurisdiction as to whether or not this person is appropriate to be licensed. So whether or not this job was good enough or good enough for the standards in the contract can be more of a civil matter between the client and the architect rather than a licensing matter.
Thank you.
We do refer a lot of cases back to the consumer and say that you need to file a small claim suit to deal with this.
Thank you. Are there any other questions or comments from the board? Seeing none, we'll open the floor to public comment if there is any or questions. Seeing none, I would ask the moderator to open up the online channels for public comment or questions.
If I may ask,
We-
if the board members online have any questions first?
Assuming that they're still there.
Sorry,
No
board
ques-
members
No
online.
questions.
Thank you.
All right, shall we proceed with public comment via WebEx?
Yes, please.
All right, we are open for public comment via WebEx. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. For our mobile device users, you may need to hit the ellipses button, that's the ... in order to find your hand. We're going to take a few seconds now to see if we have a request for public comment. Seeing no request, you wish to continue with the agenda?
Yes, please. Thank you, Michael.
Thank you.
So we're going to, Laura, do you think we could get through the next one before lunch, or you want to pause?
We can, or we can take like a 5-minute break if anyone needs it. I can push through whatever you.
So let's,
Gonna be able to finish by 12:30?
I mean, I talk pretty fast, so I can try.
so you want to take a 5-minute bio break and then come back and see if we can get through the agenda?
That sounds.
Okay.
Thank you. Yes, we're going to take a 5-minute break just for public notification. And we will return at approximately 12:12. Thank you. Thank you very much. We are now going to call the meeting back in session. To legal counsel, are we required to take roll, or are we good?
For a break, it's not required, but if it's certainly we need to, we absolutely can.
We don't need to, we won't. So we will now move on to agenda item J, the NCARB update, please.
Okay, I'm just going to briefly give an update on this. There's a lot of material in your packet. The NCARB annual business meeting is later this month. We were approved to travel to that, so Ron and I are attending. You can see the agenda, and then there are several resolutions. On the agenda, there are 2 mutual recognition agreements, one that is brand new for South Africa and one that is an updated one for Canada. It's something NCARB has been working on. There was one on Costa Rica and at that government's request that is postponed for a year. And then there are a few other resolutions, one updating terminology when referring to foreign architects to international, and another one to modify the alternative education requirement. When someone is licensed that way now, they need to be licensed in good standing for 3 years before they can apply for an NCARB certificate, and they're going to eliminate that waiting period. There's a summary in here, and then there are also the text of the resolutions. If there are any questions from anyone. And then so if we can open for public comment on this item, item J.
So any comments from the board? Any comments from the public in person? Seeing none, we will ask the moderator to open the channels up for any comments from board members that are online.
We are open for public comment via WebEx on all of J. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of your screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a few seconds now to see if we have a request for public comment. Seeing no requests, you wish to continue?
Yes, please. Thank you very much.
Okay, so moving on to update on committees, I'll start maybe from the bottom first. So on July 24th, there will be a professional qualifications committee meeting. So staff's currently working on that agenda, and so more information will be forthcoming on that meeting. LATC met on May 16th. We do have our chair here attending virtually, so thank you to Pamela. Just briefly, they had general update items. They had a presentation from Office of Professional Exam Services on like exam development and that process, as well as discussion on their approval of the UCLA extension program, which is a extension certificate for landscape architecture. And then there was an REC meeting on May 8th. And Robert, I don't know if there's anything you would like to talk about on this. We did have in the last items talked a little bit about that committee meeting, but if there's anything else you want to add.
Yeah, Mrs. Spangett discussed a lot of it. We discussed the enforcement program and some legislation. It looks like the architects and training issue is back on the table, along with the commercial interior designers discussion we had. And as Mr. Jones asked about, we're looking at the language to make sure that it's clear that in the planning department scenario that they need to look for architectural stamps as well, not just the building department. Discuss AI and the whole use of the additional training each board meeting as we already happened today by the enforcement department.
Thank you.
Any questions from members on any of the committee items?
So we should open it up again. I'm going to ask board members that are online if there are any comments or questions. Seeing none or hearing none, we will now open up the floor presently in person for any comments from the public. Seeing none, we'll ask the moderator to open up the online channels for any comments or questions from the public.
We are open for public comment on agenda item K. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take a few seconds now to see if we have a request for public comment. Seeing no request, do you wish to continue with the agenda?
Yes, please. Thank you very much. We will now go to agenda item L. Is that what you want to go, Laura?
Yes, please.
Question?
Yes, please.
I may have missed it. I apologize I did, but where it said under the NCARB, discuss and take action on candidates, we actually don't have to take action, or that's a misprint?
We don't. I don't actually think there are any contested elections at this point either. So I think we just have as a general item in case if there was a need for it. But in the past few years, we haven't. We've had sometimes a discussion of candidates, but then leave it to the voting delegate to make the decision at the meeting. All right, so on to the executive officer's report. Starts on page 110. I'll go through the highlights. Last month, we distributed the spring edition of our newsletter. We already had a budget presentation here. We've moved into the next phase of business modernization with our Connect program. So continuing to streamline that process and see what services we can continue to provide. We hired a new cashier. Our longtime cashier retired. And Bethany, who was our public information technician, who did our social media post, got a promotion and moved to LATC. On to outreach, the board participated in a wildlife recovery and rebuild conference in Pasadena in March. And then as Mike mentioned during the enforcement presentation, he's doing an upcoming one with AAA on a similar topic. You can see our social media posts with our number of posts we've had. There's details on our regulatory proposals, but we already had kind of an extensive regulatory item, so I'm not going to review those. So moving on to the licensing and exam statistics, you can see the CSC performance. It's actually fairly good for both in-state, first time and repeat. And then onto the ARE data and onto table C, you can see the comparison between California and national performance. And it's actually, it's improved maybe from prior reporting periods. And then there's similar data for LATC with their supplemental exam. And then moving on to enforcement, you can see here, this was a question earlier, the most common violations for architects, which are pretty consistent: misuse of the term architect, practice without a license, a CE audit and compliance, written contract violations, a signature stamp on plans and unauthorized practice, and then negligence or willful misconduct. And then, so there's statistics on the number of complaints received, how long they're taking, as well on the next page, similar data for LATC. Their most common violations are quite similar, except that they do not require continuing education, so they don't have audits or violations. And then on from there, you can see a summary of all the citations that were issued over that last quarter. Anyone have any questions?
I'm sorry, I do.
Yeah.
And so I'm curious, and this is a broader observation. I'm looking at the licensing examination programs and the pass rate
Mhm.
and the just the pass rate of repeat intake and reciprocity repeats
Mhm.
are just so drastically different. And if we basically, I know we've talked about this a lot, about what do we attribute that to? And for example, the pass rate for repeat in-state repeats are 68%, but reciprocity retakes or repeats are 81%. And so that's a pretty substantial difference in performance on the examination.
I mean, this is a fairly small number for this quarter, so I think we could maybe gather a year's worth of data, provide that, and look at that to maybe have better data sample, and you can see if this is something we want to address. I will say at the last meeting for LATC, as I mentioned, they had testing staff do a presentation kind of on that process, and pass rates are part of that discussion, so that might be something we want to bring back to the board for a future discussion as well, to give the members more information on how that works and what they look at.
Yeah, and I know part of this is part of our conversation about engaging academic programs, about better preparation. And if you look at professional practices is where the most struggle occurs in this examination. Again, I attribute it to largely in part to the fact that we don't teach professional practices. That you kind of learn that sort of on the job training. And so if there's a way for us to kind of look at this with a bit more intentionality, I think would be helpful.
Thank you. Any other questions?
I don't have questions, but I just like to kind of put some pins into some of the tasks that we thought we were going to conquer this year. For instance, we thought that maybe it would be a good idea to put some welcome messages on video from our current chairman so that we can educate the public on what to expect. Once you become an architect, or if you're thinking about becoming an architect specifically for unrepresented or low represented communities. I also think that it'd be a good idea to put another video by one of the board members to talk about what to expect in a fire like we have, or in an emergency situation. So that way they get on the website and they're confused and they need a little bit of calming. And I think we can provide that. I think we talked about doing a couple of other things. I can't remember, but I will, and then I'll send an email to Laura. But I think those two things will help our community as a whole to be able to have some information readily available. And when you're in crisis, you can read and read and read, and then nothing stays. But if you could hear it in a video or audio, I think it'll stick a little bit more. So I would like to.
Thank you for both of those. We didn't have on here, but also communications will meet later this year. And so I'll make sure we include both those items in that committee's agenda so they can develop those further.
Right. And it is my understanding that DCA already has a production team, right?
They do, yes.
Yeah.
So we can ask for their assistance.
Thank you.
Creating.
Any other questions from the board? Seeing none, I'll ask board members that are participating online if there's any questions there or comments. Hearing none, we'll ask the public that are present in the room if there are any public comments. Seeing none, we'll ask the moderator to open the portals to online comments from the public.
WebEx open for public comment on agenda item L. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand. And we will call on people in the order we have requests. We're going to take just a moment now to see if we have a request for public comment. Seeing no request, do you wish to continue with the agenda?
Yes, please. Thank you very much. So we're going to move on to agenda item M. And Laura, if I could basically just kind of inject something here. When I read through the reports on this, I was a little confused in some instances. And you guys oftentimes hear me basically say, when I'm looking at legislation, I'm asking what problem is it solving? How does it make what we do better? And what is the operational and fiscal impact to our staff? So as I was going through these, some of these I just couldn't make sense of. So I'd love to hear the backstory behind some of them would be really helpful for me, particularly the first one.
I ask myself that question every time I review legislation, and I wish the legislature asked themselves. Okay, so AB 667 by Assemblymember Solash. This requires boards and bureaus within the department to permit an applicant who cannot speak, read or write in English to use an interpreter at no cost to the applicant when taking a state-administered license exam. So we would then pay the cost of the interpreter. I don't know specifically what their exact problem is. There are some boards within the department that serve a lot of licensees that speak different languages, but those boards typically translate their exams, like Barber Cosmetology translates a lot of their exams materials into Vietnamese and other languages that their licensees speak. Contractor State License Board takes a different approach, and they allow someone to bring in an interpreter, and they approve the interpreter and can use them on a case-by-case basis. But there isn't anything along these lines of requiring them to provide a translator. So there'll be kind of some practical impacts of like what that does to the time and how they're approved. I would imagine the problem they're trying to get at is there are people who, particularly in an exam that is got a lot of technical language, that it might be a challenge for people to pass the exam or to have to deal with maybe the stress of taking the exam and trying to pass it in a set time frame, and then also trying to translate to themselves. And
in our interest to protect the public interest or the health, safety, and welfare of the public, the notion that there's an architect who can't read, write, or speak English, how does that basically not put the public in harm's way?
Good question.
Okay.
And how they would serve, the community. Yeah.
Just again, and I have no objection to, I'm just trying to figure out what is the principal goal.
And then they still would then be subject to all the requirements of the Architects Practice Act, such as the contract, and that's, so.
Okay. No other comment.
Okay.
Is the bill requiring to ask the architect board to pay for the interpreter?
Yes.
Yes.
We don't have the money. How is that going to happen?
Right.
Are we going to?
Hopefully it's not many. Yeah. This wouldn't specifically allow us to increase our fees, so it would just be a general, looking at the impact of it and what it does to our fees. And Tori,
But in the spirit of
as are most programs.
in the spirit of the legislation, though, it's really about inclusion,
Yes,
right? So you can't necessarily object to that.
it's a
but
good intention.
Yeah. And I'm just trying to basically bridge the intent with the actual application.
Yeah, yeah. And when it originally was introduced, it would have applied to exams that we contract for, which is like the ARE. It would apply to our supplemental exam because we developed that, but not the ARE, that would be a lot more challenging.
Right. Okay.
All right.
Anything else? Okay. Sorry.
That's
And
fine.
we can do this all at once, right? Okay, thank you.
So the next one is AB 671 by Assemblymember Wicks. This creates an accelerated restaurant building plan approval process to allow qualified professional certifiers, which includes a licensed architect or engineer, to certify compliance with applicable building health, safety and codes for tenant improvement plan relating to a restaurant. So it's specific to a particular type of project, but it is going to be an expedited approval. So the responsibility is on that licensee to make sure it's compliant.
Like a self-certification.
Like that, yeah.
But it still has to go through the Department of Health.
I mean, it'll still go to a local building department, but it's not like there's no pre-approval.
Gotcha. Okay.
So it's, I mean, it is limited in scope, so it'll be interesting to see how it
Interesting.
works out.
And
yeah.
is it limited to certain specific types of projects? I didn't read
Yes,
that.
it is for restaurants.
But particular types of restaurants or any
I
restaurant?
think any restaurant.
Interesting.
Yeah.
Okay.
So the next item is AB 742. This one directs the Department of Consumer Affairs to prioritize license applications of potential licensees who are descendants of slaves, and special priority would go to descendants of people who were enslaved in the United States. There is companion legislation this bill is attached to, and it comes out of a reparations commission, that there would be an entity in state government that would determine if someone qualifies for this status. And then if they do qualify, then the boards would expedite their license. In the past several years, the state has created expedited licensing for a couple different categories, like military veterans or spouses of military. So this would, it's similar language to what exists for those. It's not exactly the same, but there's always the question of when you prioritize for one group, that just really means you're slowing it down for everybody else. You don't charge another fee for priority processing.
And what does that look like? I mean, what does it really look like?
It just means they would sort of like jump to the top of the pile as they come in versus other applications that are there. I mean, our process isn't super long as it maybe as it
So
could
in
be
the
at other
application
programs.
process, I would check off a box that says I'm a descendant of slave.
Right.
And
And we'd have this other entity that would verify that, so we don't have to do the verification. But yeah, so it,
But then that person automatically moves to the front of the line.
Mhm.
But there's no material distinction between the examinations are still the same. It's
right.
just
They still have to meet all the requirements. They just get to have the process moved a little bit faster for them.
and you're saying that there are other categories with similar language.
There are, yeah.
And again, this is really about inclusion.
Right.
Because I'm
Or
always
maybe trying to, is some type of remedy for past harm.
Gotcha.
Mhm.
Okay. So this again is me trying to reconcile.
Yeah, there's an unusual group this year, Bill.
That does make sense. Okay, thank you.
I would like to add that for this particular one, DCA's overall concern is that DCA is hoping that it will be amended, that if there's any litigation on whether or not someone has been been prioritized or was not prioritized, et cetera, that litigation is paid for by the state rather than each individual board and bureau to handle individually.
And is this design, is it really looking at protected classes? And I mean, there are other communities that have been harmed through various means. Is this sort of a pattern that we basically anticipate happening repeatedly? Because somebody had to bring this forward.
Right. It's possible that if this was successful, someone would bring another group forward. Yeah. Okay, I'm actually going to skip AB 759 because we do have comment on that. So I'll just quickly do the other two and then we can come back to it. So AB 1341 provides that the unlicensed practice of architecture, landscape architecture, engineering, et cetera, by a landscape or by a licensed contractor constitutes cause for disciplinary action by the contractor state license board. So this is something that this didn't come from our board or any of the boards, but we thought it was a good idea. It would allow CSLB to discipline their own licensees when their licensee has violated our law. So it doesn't mean we won't do our own investigation, but it's just another tool that could be used.
Okay.
And then if there are no questions on that one, SB 641 by Senator Ashby provides boards the ability to waive certain provisions when there are declared federal, state, or local emergencies. So this is something we've kind of done on a ad hoc or case-by-case basis after an emergency, and this is going to more clearly define, so we're more prepared in the next emergency rather than waiting for an executive order to determine what could be waived. And so ready to go. So I'm going to go back to AB 759 by Assemblymember Valencia. This bill is sponsored by AIA California, who's here today. We have Nikki Stevens with us. And this would create an architect in training title for individuals who meet certain qualifications, which include passing one division of the ARE, it would be kind of it would be a title that is created, that someone need to apply for. It's limited on what they could do with it. They can't advertise with it or offer services. So if this goes through, we could charge a fee for the application, and review someone's use of it before they could go forward with it. And it does have a sunset date, and there are kind of parameters in place for that. So I don't know if you want to have Nikki come
Please.
speak, and I think we have a few people online from AIA as well.
Thank you.
There we go. Thank you. First, I want to thank the board for the opportunity to talk to you about this today. For Ms. Stedelmeyer, new to the board, if you're not familiar with the American Institute of Architects California, we're the professional association for architects in the state. We represent about 11,000 architects and design professionals. And you know, Mr. Jones started this section and asked the question, what problem are we trying to solve here? I think all of you are well aware as you review the examination statistics and you look at the trends of the number of people coming into the profession, that we are, unfortunately, we're losing more than we're bringing in. And having worked for AIA California for over 25 years now, I am absolutely seeing a change in this profession. And I feel so strongly and passionately about the value that architects provide to our state and our in solving some of these big challenges. We have to do everything we can to encourage this next generation. This, you know, again, Mr. Jones' question about what problem is this legislation trying to solve? It is not going to solve the problem. But we have to do something to increase the pipeline of people coming into the profession. We know this pipeline is challenged. We know that this is a long and complex process to be licensed. We know it's an expensive process and there are financial barriers for many. There are limited access and equity issues, and there's shifts happening in our society over career preferences. And so you look at people that are passionate about architecture as a profession, and we need to do everything we can do to keep them on the path and support them along the way. Providing this title is one small way that we as a profession indicate that they are valued. And that we recognize that they are committed to this journey of licensure. And I think this is an easy place to start with an already tested program. As Laura mentioned, this designation, Architect in Training, is patterned after two other boards who use it, the engineers as well as the land surveyors. It reinforces the consumer protection by identifying people who are on the path of licensure without allowing them to offer their own independent services. There are guardrails in this program, and it is very structured way. And finally, it is an optional program. We know that not everyone along the path of licensure will use it. They have the flexibility, but for those who choose it and want to have that designation, we think that this is a good opportunity for it. And finally, I want to emphasize, you know, we were in this process that has been happening for, over a decade now. We've had a lot of time to talk to people about concerns. We recognize the value of the title architect. We don't want to do anything to diminish what that means, but we also recognize that bringing people into this profession and providing those services that we know are an important part of the design and construction process is important as well. This bill prohibits AITs from independently offering architectural services, and any misuse of the title would constitute unprofessional conduct subject to the board's enforcement process. And so, and finally, the public will have access to verify whether an individual is authorized to use AIT title through the cab, and we're adding a layer of transparent consumer protection. There, as Laura mentioned, we have several other folks who are very passionate and focused and committed to this process and to this legislation. And I'd like to first ask if there are any questions that I can answer, and then invite them to join us virtually.
I have questions, but I can wait until the rest of the presentation. If you would like, or you want me to ask now? Sorry, I just, so is the thought that in architect in training will have this for how long of it's his or her journey in the architect
So
field?
it's a 5-year.
5 years, so it would cap at 5 years.
Yes.
And what is, not subject to this, but what is AIA doing to ensure that more diverse students are getting into the system so that we have more on the bench to become architects?
So that's a complicated question. For those of you who aren't aware, AIA California is the statewide organization. There are also 21 local chapters throughout the state. And they range from, some of the largest components in San Francisco and Los Angeles to some of the smallest in Bakersfield and Palm Springs. The access to people entering the profession and support for those people is also varied. AIA California is stepping in to try to bridge that gap more equally. We've created a free for all statewide study hub program. People come in and out, they study with their peers, they make connections and network. We also have an intense outreach program to the schools, and not just to the accredited schools, but also the community colleges, because we know, that is the differentiator in moving people through, people disadvantaged, underserved populations through the matriculation process. So there's things that we're doing, and I look at this as kind of spokes on a wheel. We are all trying to address this, the central issues of how do we get and keep people in this profession.
Nope, thank you. As you realize, this is my first meeting, so maybe I'd be asking for some information that is well known, but I appreciate the information. So my understanding is that the person would be identified the board as kind of architect eligible, pass a part of the test, and then be able to have this title for 4 to 5 years.
Correct.
How does that increase the pipeline? To me, I worry about, is it that the candidate just feels, oh, all I have to do is pass part of the test instead of the whole of the test? Or are we looking for different eligibility criteria as they sit for the exam?
So there's no different criteria. So they have to pass the first test, and then they are eligible to use this title.
Okay.
I think the question you're asking is, how does this process get more people interested in going through the process? And I think it demonstrates a very public way that we are recognizing the people that are in this profession, that are working, that are on this journey, and they can be publicly recognized, celebrated, and acknowledged for being part of this profession. It is a cultural shift that we're talking about here. This is not a direct, like it's going to, result in 500 more potential candidates. It's nothing like that, but I think that it is one of many things that we are going to have to shift to make the profession more accessible and of value and of interest to emerging generations.
And to clarify, so once they have the architect in training title, what are they allowed to do in terms of practice compared to someone who is not set for any of the exam?
So they are still working under the aegis of a licensed architect. They are still working through their experience hours. And they are still in the process of taking more exams. So this title does not authorize them to do anything different. It just acknowledges that they're an important part of this profession and they are working towards this goal of becoming licensed.
And so do you think this would help, for example, like membership, professional association membership, because now they have a qualifying title? Where do you see them using this title to their benefit?
So where we see them using the title is in their professional work. So firms that are including these emerging professionals as part of the team will then be able to recognize them as on this path, and it validates the strength of their team. And frankly, they use it as an individual. Hey, I am, they're holding that moniker up as I am on this path. And, the tangential encouragement that they'll receive from others, but also that they're proclaiming that this is an important journey and I'm committing to this. And so there's not, we don't see this as they are authorized to do any additional work. It's just recognizing that they are committing to this path to licensure.
Thanks.
Currently, the AIA has two classes of membership, I believe, right? Associate AIA and AIA. Is there going to be a mid-tier category?
No, we do not expect that the architect in training category will be something new. I will say the different membership levels is designated by the national organization. Those who are not licensed fall in the associate category. There is a lot of conversation right now happening about how do you differentiate people in that associate category, those on the path to licensure, as well as those who are career professionals who will never be licensed. And so that conversation is happening independently of our initiative.
But so you're encouraging the state to recognize this distinction, but your own organization isn't recognizing the distinction?
Not currently.
Okay.
We like to think in California, we're getting out ahead of it.
Gotcha. Okay, thank you.
Just from the disciplinary standpoint, if someone in this state, in this category, I should say, does something bad while they're in that position, are they now treated and can be disciplined like architects? Or are they treated like unlicensed architects? Or is it just a black mark when you apply to be an architect? Or does the bill create its own disciplinary or regulatory sanctions, procedures for people in that category who may do bad acts?
So they would be disciplined just like any other unlicensed person. We don't have a caveat, you're in this program and so you did something wrong and that will preclude you from becoming licensed. I think that disciplinary action will play out, and we'll have to look at, is this causing an additional level of problems that then we need to address? And that is part of this as well. This is a pilot program. And so the board will have to look at this and evaluate its effectiveness and maybe its increased level of disciplinary actions. And if it's found, then we would have to address those.
What's the timing of the bill passing through the legislature and potentially the governor's desk? Where is it at in the process?
It's currently in front of the Senate and awaiting that hearing. It passed the House, and we've received a lot of support, a lot of interest from the author's office, and we are addressing a lot of questions that both this board as well as other groups have asked about the bill. And so I have a couple of members who are joining us virtually today that I think you would all benefit from hearing from. They've got some both personal insights as well as kind of larger industry insights. So.
I do have.
Would we invite them?
Yes. Give me one other question.
Okay.
I do have a question before we do that.
Okay.
So it appears, I'm going to go to Member Stoudemire's question about the why. And there's no benefit to the public, no material benefit to the public relative to health, safety, and welfare. I think the advocacy position that you guys have communicated is really as a retention mechanism to, because we know that the retention level for applicants drop off after a few years. And so this is a way of encouraging them to stay engaged. And I think that that's a really good thing. So I wanted to make that point, is that it's really, for me, about retention. The third piece of it, though, is that, or the second piece is that we are now elevating or creating a status or category for licensees, potential licensees at some level. But the level of expectations of them with that elevated status doesn't necessarily change. And so we basically take an unlicensed individual and we have standards of what they can and can't do. We're creating now this elevated status of that same position, but their standards are no different than a person at the lowest standard of competency. Is that a fair assessment?
That is a fair assessment.
Okay.
But I would want to back up a little bit in one of the comments that you made is there's not a public benefit, because I absolutely think that there is a benefit to the public to understand who they are working with, who's working on their project. One of the things that we did after meeting with Mr. Jones and Laura earlier in preparation for this is there were concerns about, well, how does this affect consumers? How does it affect the public? And to that end, we recruited a number of different people that work in this industry to talk about specifically why this matters to them and the potential value that it provides. I was going to share that during the public comment period. I can do that now if you would prefer.
So unfortunately, we have lost our quorum. But so what we're going to do, just for public notice, is that we're going to basically allow you to finish your presentation and allow the other speakers to do the same. But we will not have discussion because we've lost the ability to have discourse. But I want to basically let you finish your presentation. And I think you mentioned you had some other participants as well. So let's do that.
Okay.
And you can call on them whenever you
Okay,
can.
great. I'd first like to ask the board to hear from Ginger Thompson, an architect from Sacramento, who was going to join us and talk a little bit about what this means in terms of diversity and ensuring the pipeline.
Can we call on Ginger, the moderator, please?
This is the moderator. Go ahead, Ginger.
Hello, thank you. Thank you very much for letting me speak. And I hope, I'll try and turn my video on. I don't know if it's going to work. I hope my phone is okay. I'm speaking from outside. I'm actually in Boston at an architecture conference. I just want to start with saying congratulations and thank you to the board member, Nilsa Serrano, for your dedicated tenure to both this board and the future of this profession. My name's Ginger Thompson, and I'm super honored to be here to speak on support of this bill. As a background story, I found architecture at 30. It was not something that was introduced to me when I was growing up. So I had actually spent over a decade in behavioral analysis, a field that I left in the search of something that had more creativity to it. Is my sound okay?
Yes.
Yes.
Okay. I did have a friend who was studying interior design who introduced me to the power of what interior design brings to the table, and I knew I found my calling, not in interior design, but in architecture. But at 30 with kids, it was not a simple thing. Every accredited school program around me required a relocation, and I had 3 children at that time that were all in school. So thank you, California. I had the opportunity to carve my own path. And I went to a community college. I did internships, I did jobs that taught me all the skills that I needed to do the trade. I learned CAD and traffic planning, I did BIM and with engineers, and I eventually earned my space at an architecture firm. But it was slow, and often I was invisible. because I did not have a degree and I was older on the end. But I kept going because I believe in what architects bring to the table. I believe in the work and I believed in who I was becoming. I did become eligible for my first licensure exam in the year of 2020. So it was over a decade after I had started. And that milestone was everything. And it took such a long time. And I still had really nothing to show for it because in order to talk to people about what I did, and by that time I was managing projects, I could not share the fact that I was anything of an architect, which I wasn't. But I also wasn't a beginner. I was in the work of getting there, but I didn't have a name yet. The thing is, licensure attrition's a real problem. Only half of California candidates that stay active after 5 years, and for the Black candidates, that drops down to 42%. The median time to licensure here is 13 years, and that's post-graduation. 13 years before you can even get your license, and it's even longer for underrepresented groups. We're talking 19 years average for the Black community and 14 to 15 for those who are Latinx. This bill is bringing something that gives a formal recognition to the process and path in one exam. It's giving a time-limited architect in training title. And it's a signal of a commitment. It's a way to stay engaged. It shows the employers and our peers and even the owners that we're working with that we're serious about this profession. This bill acknowledges that licensure is a journey. It's not a switch. And it keeps this profession accessible, resilient, and inclusive. I appreciate your time. Thank you.
Thank you very much.
Now I'd like to ask Liam Hanlon to join us from San Diego.
Moderator, can you provide access, please?
This is the moderator. We have Liam Hanlon. You should be able to unmute at will.
Oh, can you hear me?
Go ahead, please.
Excellent. Thank you. The video's given some issues, so I'll just do audio. But hello, my name is Liam Hanlon, Associate AIA. I'm the California State Associate Representative, Vice President of the Mac Academy of Emerging Professionals, and a designer with an accredited degree in architecture, over 10,000 NCARB hours worked and approved under the supervision of an architect, and have passed one division of the ARE. Today, I'll be speaking on behalf of emerging professionals in California who represent over 20% of AIA California's membership. Supporting AB 759 would help provide clarity for design professionals working in the field of architecture who are actively working on pursuing licensure and provide a designated title for people in this defined stage of their career. As a member of the National Associates Committee, which is made up of one representative from each state, this has been a major concern for the retention of the profession and main focus of the advocacy task force for the 2 years for creating a national standard for titling. Many other regulated professions have defined titles for this career phase, including those in the building and construction industry, such as engineer in training, land surveyor in training, and geologist in training, to name a few. In addition, 28 other states currently have provide title recognition for unlicensed architectural candidates, and I believe that supporting this bill would help secure and retain the most qualified architectural candidates moving forward. The AIT title is not just a name. It's a professional stepping stone that enhances clarity, equity, and accountability in the licensure process. Thank you for your time.
Thank you very much.
Thank you. And lastly, as I mentioned, we secured testimonies from 3 public members, or members of the public, guys, who weren't able to join us today just due to schedules. And I'd like to share these with you. The first one is from Mike Meredith. He is CCM and DBIA fellow and currently a vice president, director of design build program services with Vanner. Mike says, as a former public agency employee, he was the capital outlay program manager at DGS. I see advantages of the AIT designation. It can be very helpful in comparing potential candidates for consulting work. A typical public entity owner sees many resumes in the RFQ proposals and selection processes. Seeing an AIT designation identifies that an individual as someone pursuing fully licensure in a recognized regulated process. Further, I could see a distinction in candidates motivated by career advancement and in general furthering their knowledge as they stay abreast of architectural best practices. In addition, the designation AIT allows owners to have more metric to gauge talent. Overall, I see this as positive in the industry. Next, I'd like to share comments from Tanya Chow Shea. She's the former undergraduate dean of the College of Environmental Design at UC Berkeley. The proposed architect and training designation is a vital and long overdue step. It brings architecture into alignment with other licensed professions such as engineering and provides meaningful recognition of the years of study, design thinking, and ethical responsibility undertaken by those on the path to licensure. It not only elevates aspiring architects, but reinforces public trust in the integrity of the profession. And then finally, Alex Grossen. He is a owner's rep for Landmark PMLA in Los Angeles. Alex says, as an owner's rep who works with many different architects, their teams are typically a combination of licensed architects and unlicensed staff. I'm not sure how to refer to their staff when describing them to the owner. Calling them staff seems to undervalue them and does not adequately describe them. I'm aware in the state of California, I cannot elaborate with the term architectural. So having a sanctioned term such as architect in training or AIT will allow for clearer description of who they are and what they do. There are many other testimonials that I'm happy to share with the board. As we started asking these questions in response to our conversation, I was surprised and heartened by what it meant to others outside this profession. And I think that this is an important recognition that not only benefits those on the path, but also benefits the profession as a whole. So, any other questions that I can?
So you had time for just a couple?
We can't ask questions,
Right.
unfortunately.
Oh, I'm sorry.
But Nikki, let me say this is that I think it's in fairness to you, we would welcome you back for another opportunity to have this conversation. I think it's really important. So I would basically at least ask Laura to kind of facilitate that going forward.
Happy to.
And we will be, I'm not sure, are you in, what city are you guys?
Sacramento.
Okay, we're in Oakland next board meeting, so,
Be happy to join you.
okay, thank you.
We can just adjourn now. That was our last item.
Yep. So,
We should probably open for public comment,
okay.
general public. comment.
Okay, so let's do that, but no discussion, just public comment.
Correct.
So let's first ask anybody, any of the board members that are online, if they have any questions or comments. Seeing none, we'll ask the public in person if there are any public comments or questions. Seeing none, we'll ask the moderator to open the portals for public comments online.
We are open for public comment on agenda item M. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand. I have noticed a few hands pop up and down over the course of the discussion and the presentation. Now is the time to get them back up if you'd like to make a comment. Seeing no requests, you wish to continue?
Yes, please. Thank you very much. So the last item is the upcoming meeting dates. We need to announce that, or are we good? Okay. So I think our business is complete and we are officially adjourned. Thank you all for your time and your patience.